We are live and recording.
Good morning and welcome to the August 22nd Committee Bar Examiner meeting. As a reminder, this meeting is being recorded. Devin, can you please call roll for us?
Bolton, Cow, Chan,
Yes.
Gongora, Kaplan,
Here.
Kramer,
Here.
Lawrence, Lynn, Masiwala,
Here.
Montgomery,
Here.
Peak,
Here.
Silva Guzman,
Here.
Smith,
Here.
Reyna,
Here.
Reyes,
Here.
Yokelson.
Here.
We have a quorum.
Thank you. We have two members appearing remotely today, Judge Reyna and Mr. Kaplan. We miss your presence. Hopefully you get to join us next time. As required by the Bagley-Keene Act, Open Meeting Act, members appearing remotely must appear visibly on camera, except if a member is unable to appear by video due to connectivity challenges. And if that is in fact the case, please provide an explanation. Members should also raise their hands when leaving and returning to the meeting if they will be absent for more than 5 minutes. First up on the agenda is call for public comments. Before we do so, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to the items that are on the agenda for today and be related to matters that are within the jurisdiction of this administration. Specifically, the committee exercises oversight on admissions matters, including the California Bar Exam, the first-year law students exam, more character applications, and law school regulation. The CBE does not have authority over attorney discipline, and there are no attorney discipline matters on the agenda for today's meeting. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments. We thank you for that. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers. Also, we have a full agenda for today's short meeting, and as the chair, I am going to exercise the option to limit each speaker's time to 2 minutes or to close the public comment period after 2 hours, which also includes a 10-minute break, or after the first 100 speakers, whichever occurs first. And for those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and the committee coordinator, Devin, will call on you in the order that hands are raised. And for those who are participating by phone, you may virtually raise your hand by pressing *9, and that is the star button, followed by the number 9. Again, doing so will alert the staff that you would like to make comments, and the committee coordinator, Devin, will call on you and open your microphone so that you can address the committee. And for those who are participating from a noticed location, please let us know, or the State Bar staff member present in the room, that you would like to make comments. The staff will have an on-screen timer visible to all attendees during the duration of your public comments. The timer's 2-minute countdown will begin as soon as you start your comments. The on-screen timer will flash throughout the final 10 seconds. With that, Devin, do we have any advanced signups for public comments?
We do. Our first public comment will be from Benjamin Cohn.
Okay. Mr. Cohn, you may proceed.
Well, thank you. I would like to start with the exam software vendor selection, and the agenda does not have an attachment listing any vendors that have bid at this time, but I will assume that there are multiple vendors presenting, and I would assume that one of them is ExamSoft, who had proctored the July 2025 exam and most exams before that. I would urge the committee not to recommend use of ExamSoft going forward based on the fact that ILG had submitted a lower bid by $300,000 for the July 2025 exam that was rejected out of hand and perhaps unreasonably, and based on the fact that ILG generally has been more reliable, whereas ExamSoft had in July 2021 a pretty large meltdown that prejudiced a large number of applicants, and on a smaller scale had a number of crashes on other exam cycles. They may not be as unreliable as measure learning, but measure learning is not under consideration either. The beyond ILG, if there are other vendors, I would strongly suggest consideration of Prometric and Accredited. And specifically, I think that there needs to be functionality to support camera based live monitoring by live proctors offsite, which I understand now is a requirement for certain testing accommodations, and that the live proctoring from an offsite location should not be electronic or AI based. I understand that there are vendors on the market that offer this through multiple cameras. It should provide support through Bluetooth for body cameras to handle mid-test session restroom breaks. The next thing that I wanted to comment on briefly was that the report to the Supreme Court on the February bar exam acts like it's final who received remedies, and there really needs to be more information about the ongoing Humro investigation and the potential for changes based on failures to implement approved testing accommodations on that report on the February bar exam, make it seem like it's not final. Thank you.
Thank you.
Thank you, Mr. Cohn.
Our next public comment is from Ray Hayden.
Right, lower my hand here. There you go. Anyways, Mr. Alex Chan was on the Blue Ribbon Commission along with Trustee Ryan Harrison, and I was at all the Blue Ribbon meetings, and I actually applied to be a member of the Blue Ribbon Commission. So I know that Alex Chan gets it, and I also know that Mr. Harrison also gets it in terms of being able to make an exam that can work. It has to be remote because I'll use the new lingo. It's more fair to the exam takers. Also, it's phenomenally less expensive. Researching all other available opportunities to test now that CalBAR is trapped within the 2-year rule, which all of my suggestions always avoided. But now you're stuck in a 2-year rule because the legislation's pushing for it, an expansion of the 2-year rule requirements. Cal Supreme Court mandated a change in the exam that locks you into the 2-year rule, and the change of vendor thing with the legislators thing that locks you into the 2-year rule as well. Trustee Harrison, I know Mr. Chan, Chair Chan, both understand that in order to offer the exam more than twice per year, you cannot go to the NCBE, and I highly recommend that you do not. And further, that you also understand there are other better ways to get this done. And I see Donna's there. Donna also understands that there are better ways to get this job done, and I have complete faith in the parties being able to get that done. Lastly, I want to second everything that Benjamin Cohn says. He is, in my personal opinion, he is an absolute subject matter expert in all things that are related to those who need accommodations. And I also am a huge fan of remote testing. All right. The military's done it for more than 20 years. I participated in that, so it works. All right. With that, have a great meeting. Thank you very much.
Thank you, Mr. Hayden. Do we have any more advanced signups?
We do not have any additional advanced signups, and we do not have any additional raised hands. Yeah.
Do we have any in-person public commenters in the SF office?
We do not.
What about elsewhere?
We do not.
We'll now proceed with public comments from remote participants. Anyone raise their hands on Zoom?
We do not have any additional raised hands.
Okay. Well, in that case, this concludes the public comment period. We'll now begin our open session. Agenda item 1.1, chairs or report. I don't have anything at this point. Audrey or Donna, anything we need to report out? We will have certain recognition towards the end of the day, but I want to make sure that those members who are involved are present, and so we'll push it towards the later in the day. So now we'll go to agenda item 1.2, which is the adoption of charter and membership of Subcommittee on Exam Administration and Subcommittee on Exam Development. First and foremost, my apology at the last meeting. I know I was absent during the meeting, and I know there were some lingering questions, and I was able to go through the transcript and be able to identify some of those questions. And so a couple of things I wanted to address very quickly. One of the issues that was brought up is how often these two subcommittees would meet. And from my perspective, the answer is simple. They will meet as often as is necessary to carry out the responsibilities, no more and no less. And this really mirrors the model that we have already adopted for all our existing subcommittees, including more character and testing accommodations, which convene when there are only matters that require their review and input. Now, I expect the members of these subcommittees would also participate in those substantive meetings between the vendors and the staff, but ultimately the exact number will be determined by necessity and also will be decided by the chair of those subcommittees. Now, there's also another question about the composition or the number of members in those subcommittees. The structure will fairly be consistent with our existing subcommittees, and in that sense, all the subcommittees will have similar composition. Again, each will be led by a chair as well as a vice chair, and the exact number of members will reflect what is appropriate to effectively manage the volume and complexity of the work. Again, in terms of scale, is very similar to more character, test accommodation, and other long-standing subcommittees we have. Now, note this number could potentially fluctuate depending on the total number of CB members we have for a given term. The goal essentially is to ensure both efficiency and depth, and with the right number of members, we can strategically divide up the work, right? Tap into different diverse expertise, and also maintain a certain level of accountability. Now, hi, good morning, Dr. Bolton. Good to have you. While I can't commit to a precise number at this point, my current vision is really for each subcommittee to include somewhere between 4 to 6 members. Now, that said, again, this number isn't fixed. It's really a starting point based on what I anticipate the workload to be, and particularly for the first year. If, for example, the exam administration subcommittee is able to determine and complete all the major courses of actions for the future exam delivery during the first year, I honestly don't expect us to expand that group anything beyond 4 to 6 members. But if it turns out that more hands would be needed to carry out the work efficiently, the chair at that time, to be appointed by Mr. Yokosen, the chair at that time will certainly revisit the size, and ultimately the composition, again, will be guided by necessity, evaluated by the chair and the vice chair based on how much work would need to be done. Again, they will be reporting back to the CBE chair for subsequent modification. Now, flexibility is really the key here, and we want the staff, we want to staff these subcommittees in a way that is most efficient and most effective. With that, I'm going to open up the floor for questions from members of the committee in case there are additional questions I could potentially answer.
Alex?
Yes, Mr. Kramer.
I'd like to ask probably Donna, how these are going to, subcommittees are going to fit into the work that we talked about last week of answering the 2-year notice question. I think that's the first task before us. And how would they fit into that?
My vision is that the exam development subcommittee, probably in particular, would be talking about the different options, specifically the options that would require new development efforts. And so the Exam Development Subcommittee would meet to potentially hear about those options, to direct staff to get further information. My plan is that with regard to those options, there would be a presentation at the full CBE meeting in October, sort of an initial discussion of one or more of the options that had been flushed out by that time. A draft of the cost-benefit analysis presented to the CBE at the December meeting, and the final cost-benefit analysis presented to the CBE at their January meeting. And so to the extent that we can have the Exam Development Subcommittee, or if appropriate, Exam Administration, but I think mostly Exam Development, meeting in the interim to help guide staff as we are putting together that information for the full committee, that would be the best use of it.
I'd suggest, though, that a key question is the feasibility in the near term of remote testing. And that sounds like an exam administration. So should they be working on that in a parallel sort of way?
Absolutely. And this is why we need these subcommittees established, chartered as soon as possible, because there is a ton of work involved. Whether we're going to the NCBE route or doing a remote route, a lot of studies and explorations will need to be done in the short term. And so we need members of these subcommittees to start working and cranking.
So to be clear then, with this timetable, any new exam would not take effect until July of 28. Is that right?
That was what was discussed at the August 14 joint meeting between the Committee of Bar Examiners and the Board of Trustees, shooting for that July 28 deadline, yes.
I'm glad to hear that. I did not hear a firm answer last week, but I guess you did on that point. But I'm glad to hear that we're taking a little more time. I mean, I think ideally we need even more time, but at least we're taking the maximum time that's available to us to try to figure this out.
Agreed. Wholeheartedly.
What staff heard at that discussion at the joint meeting was that the board and the committee wanted more time in order to think through these very important decisions. That the staff timeline was pretty much similar to what it was when we thought the decision had to be made 6 months earlier. But that's why we've built in the opportunity for several meetings to have the discussion.
And again, I'm glad to hear that.
Any additional questions from any members of the committee? Welcome, Mr. Gongora. We missed you. Hearing none, and I don't think we have any resolution or any motion on the table. It's been voted on, and as soon as the next term begins.
Actually, we do have a motion because the original resolution that was voted on basically was a temporary adoption of the charter until such time as we came back and had a further discussion on it. So there is a resolution formally adopting the charter. There were also, especially because we thought this would be adopted in June initially, resolutions that would identify the a resolution that would identify the membership. We can strike that resolution if we are not prepared to identify the membership of the committee at this time. But being that the next full meeting of the CBE is not scheduled until October, I would love if there were members that were identified now until the new chair comes in and then makes a decision.
I think the only question I have, and I'm looking at the charters for both subcommittees. I don't know if one of the subcommittees, for example, exam development, would have to be comprised of attorney members only, especially in the areas of designing the bar exam. And this is something that I actually don't know the answer to.
It's a policy call, so there's no legal prohibition that would require attorney members only on that committee.
Right.
And so I think it could be open to all members.
This is fantastic news because I think for a while now, public members cannot participate in sessions relating to the bar exam, meaning when we design or calibrate questions, and I certainly would love everyone's participation. And so my vision would be to open it to all members of the committee. Also, in looking over the charter, I realize that the policy recommendations would have to be reported to the full committee with respect to the subcommittee on exam administration, but that provision is somehow missing for the subcommittee on exam development. I want to make sure that I'm not missing those. If so, I think my vision is really to have the same provision for both, meaning I certainly want both subcommittees to report back to the full committee, just because there are a lot of nuance and there are a lot of issues involved with exam development. That would be better off for the full committee to discuss, to debate, and to vote on, or to even ratify. But let me just open that up to members of the CBE and to get some input about this.
Yeah, I agree that these are important issues, and I would not be comfortable delegating to a subcommittee. But as we have in our consensus points, I see their role as to work this stuff up and get it ready so that when we receive a presentation, all the information we need is there. And, recommendations from them are fine, but ultimately, it's a decision for all of us to make together.
Yeah. And unlike, what happened this past year where everything was on time crunch and where we had to delegate certain authority to the chair and vice chair, now that we have a little more time with exam development, not that we have a lot of time, but certainly we have enough time to report back to the full committee. So I do think this would be something I would like to add to the charter. I don't know if we have to revoke this. I think the amendment would be to add the last bullet point for the charter, which is to make policy recommendations to the full committee of bar examiners regarding best practices and full enhancement to the exam development subcommittee. Any other inputs, objection, comments?
How do you want to hear about our interest in serving on one or the other of those?
Just email the chair, and your involvement would be much appreciated. Okay. Otherwise, Mr. Yokoson will be assigning it out to individuals.
I don't think these are committees to which people should be drafted against their will, especially.
Donna, in terms of procedure, do we need to vote on the charter again?
Yes, let's do that, but I'm going to make a quick modification to make it clear
Thank you.
that, that
We'll give you a
that the
minute.
vice chair, because he's still vice chair temporarily, that the vice chair of the Committee of Bar Examiners may appoint members. Should we say is delegated? Yeah. Is delegated the authority to appoint members to the Subcommittee on Exam Administration and
Development.
yeah, and the Subcommittee on Exam Development. Okay, the resolution is
Can we put it up just so we all can see the changes? Subcommittee for on exam development. Policy, right?
Yes, so that resolution actually deals
I
just
see, I
with
see.
that subcommittee, so I
I see.
left
Yep.
it subcommittee.
Okay.
Sharon, can you increase the size of the resolution?
How are we doing time? Any additional comments? Hearing none, within a motion.
I'll make the motion.
Thank you, Justice Ms. Waller. Second by Mr. Kramer. Any additional discussions? Hearing none. Ms. McFarland, please take roll.
Bolton?
Yes.
Cow, not present. Gongora?
Yes.
Kaplan?
Yes.
Kramer?
Yes.
Lawrence, not present. Lynn? Not present. Asiwala? Montgomery?
Yes.
Peak?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Reyna?
Yes.
Reyes?
Yes.
Yokelson?
Yes.
Chan?
Yes,
With 13 yeses and 0 nos, the motion passes.
thank you. Next up is agenda item 1.3, which is action on establishment of a subcommittee on the provisional licensure exam. This item was suggested by our longstanding member, Dr. Bolton, and Dr. Bolton reached out to me and suggested that we create this subcommittee to create and manage a certified training program for supervisors of provisional or provisionally licensed lawyers for the purpose of assuring, promoting, and producing high-quality supervision for provisional lawyers. Dr. Bolton, would you like to say a few words and walk through the committee what sort of your envision is like?
I wouldn't have anything in addition to what we have already there. I just thought that
Gene, can you
we
hit his
needed
mic?
to formalize the supervision of a provisional license, and that's why I did that.
In that sense, I do want to express my strong support for Dr. Bolton, who's been around for many years. Thank you for your service. And I want to express strong support for the formation of this subcommittee. This program, and I sort of envision this as a way to create or to expand access to the profession during, well, recall we had this provisional license program way back during the unprecedented public health crisis that is COVID. And this has sort of now become a meaningful pathway for a lot of our aspiring lawyers who are really seeking supervised legal expertise prior to full licensure. But as the program has matured over the last couple of years, well, so too must our approach to ensure their success. And the integrity of provisional licensing depends not only on the quality of these lawyers themselves, but also depending on the quality of their supervisors. As you can imagine, if the supervisors aren't really giving them the necessary supervision, well, you can imagine how those lawyers would turn out. And so and this is the reason why I believe in this subcommittee as recommended by Dr. Bolton. Now, the central task of this subcommittee, which is really to develop and to manage this certified program for supervisors, will in many ways, and we have never had anything like this before, but if and when it is established, it certainly will help those supervisors or those who are supervising the provisional lawyers to be better equipped and more well-informed and at least fully aligned with the standards. And we don't have any standards at this point, but to at least align with our standards that we expect of those who are helping to shape this next generation of lawyers. And so this is in many ways not just about compliance or formality. It's really about, in many ways, promoting excellence. And again, effective supervision is really a skill. And a lot of us sitting around this table are, oftentimes supervising different associates or clerks. it's a skill set. It's not something that you learn overnight. And I believe it requires a lot of clarity a lot of times. You've got to have some structure to it. And there's got to be a common understanding about what high quality mentorship or supervision should look like. At least something that is aligned with what this subcommittee believe it to be. And so with this subcommittee recommended by Dr. Bolton, I think we can set expectations, because again, right now, we don't have any expectations. We don't have any guidelines or standards for these supervisors. But with this subcommittee, they can make policy decisions. They can set standards and expectations clearly, and at least elevate the experience for all the participants in this process. Again, this is something that I support, and I would open up the floor for any comments, inputs, or objections otherwise. Mr. Kramer.
I have great respect for Dr. Bolton, but in this particular case, I can't support this. Donna, we talked about setting the fee last week, and how many people maximum were we expecting to join this program?
I believe the estimate was based on an assumption of 500 people
Okay.
joining the program.
And when does it expire? End of
27, and so there's a 3-month application period from September 1st, a couple of weeks from now, to December 31st. That's the window to apply, and then the program would end December 31st, 2027. That would be the sunset date.
Yeah, so we're not talking about a lot of people. This is not a program into which we're going to invite new people. It's not a pathway to licensure for the new entrants. And we've to the extent it was a pathway for what I call the retroactive reduction of the cut score. At that time, we didn't seem to care about the quality of the supervisors. It's going to require a lot of resources. If we're going to do anything, it probably will take a year to implement. So that'll get implemented with just 1 year left in the program. And I just can't see, given our limited resources, the fact that everything we do just basically raises the fees on someone, whether it's bar takers, law schools, people in our special programs. I just can't make that cost benefit analysis work in its favor.
And Chair Chan, I'm sorry, I just want to remind the committee that pursuant to California Rule of Court 9.49, there are limitations on who may serve as a supervisor. And so to the extent this body wanted to change the requirements for supervision, we would need to evaluate what authority this body has to do that, because this is set forth in the Rule of Court that is set by the Supreme Court.
Mr.
And
Yockelson.
apropos of that, Jean or Donna, can you take us through what is required currently to be a supervisor, and what, if any, oversight we currently have?
Sure, I happen to have the rule open.
So
There are several requirements, one of which is that they must work for the same firm for which the provisionally licensed lawyer is or will be employed. They must have practiced law for at least 4 years in any United States jurisdiction and have actively practiced law in California or taught law at a California law school for at least 2 years immediately preceding the time of supervision, be a licensee in good standing of the State Bar of California or a current judge of a court of record within the California judicial branch, exercise competence in any area of legal service authorized under California law in which the supervising lawyer is supervising the PLL. And I'm abbreviating some of this, but it's all set forth. They cannot be inactive. There are requirements about disclosure at the outset of representation, what the PLL will be doing to the extent they provide services to a client. They must be prepared to assume personal representation of the PLL's clients if the PLL is ineligible to practice law for any reason. They agree to assume professional responsibility for any work that the PLL performs. They agree to notify the State Bar in writing within 10 calendar days of a number of things, including if the PLL leaves employment. And then there's some provisions about what duties they may delegate. But this is all in subsection I of Rule 9.49.
and then how is that enforced? Do they need to sign up for it, or is there oversight by staff?
Yes, so there is oversight by staff. There she is. Tara, if you want to speak to that.
Trying to move the mic, please let me know if you can't hear me. So when the applicant applies for the provisional licensure program, they have to submit the supervising attorney declaration. And that's where the supervisor confirms that they're working at the same organization, that they meet the requirements, both the 4-year and the 2-year requirement. And then they attest that they will assume the personal representation and all of those things. And so when staff processes the applications, they confirm that they meet those requirements before approving them as a supervisor.
And is there any follow-up after that?
For the people practicing in the program under 9.49, there's not follow-up. For those in the expanded pathway, the ones that are in the pathway to licensure, those PLLs do have to report their hours, and then the supervisor confirms it, as well as at the end of the program, the supervisor will do an attestation of whether or not they meet the requirements of a first-year attorney. We do monitor things on our end. We'll periodically check just to ensure that somebody, hasn't been disciplined or something of that nature, but there's no formal follow-up otherwise.
And how do we vet these supervisors to make sure that what they're attesting is actually truthful and accurate?
So we look, they all have to be admitted in California. So first we verify their admittance with us, and then if they also say that they have not been admitted in California for 4 years, it's another jurisdiction, then we'll verify that with that jurisdiction. But it's really mostly about the admission part of it.
That's it? That's the, okay.
Chair Chan.
Oh, yes, Mr. Reyes.
Yeah, of course. I'm still not clear. Are people, when provisionals sign up, are they assigned to somebody, or do they look for somebody on their own?
The latter. So they will bring, when they apply, they have to have that supervising lawyer already in hand. So it may be a conditional offer of employment. It may be somewhere that they're working and they're willing to give them, a promotion to provisional licensure, something of that nature.
Thank you.
Ms. Silver Guzman?
Is this something that we might already have some program in place? I don't know what's going on. Something is reacting. Some program in place, or an MCLE, or something that the bar already hosts. I know we have like the new attorney training, and so I think there might be I feel like there should be something like an MCLE to target the points that we think are missing or a gap for the potential supervisors.
So we've actually been in communication with COAF. They have a small working group who's looking at this, and what they're planning to do is put together like a toolbox for the supervisors, so that way we can't require it pursuant to the rule of court right now, but we can say, here are some courses that we think might benefit you in your supervisory role for the program.
And it's possible also that a group like California Change Lawyers or California Lawyers Association or the Legal Services Funders Network, which is becoming part of Legal Aid Association of California, have something like this as well, or would want to take this on. And so that might be certainly a communication that we can have to encourage that. I believe the Legal Services Funders Network had already partnered with California Change Lawyers to do something along this in this vein when it came to people who were provisionally licensed lawyers who were working with IOLTA-funded organizations. I don't have the exact strong memory of it, but that's certainly something that we can look into and encourage people in that direction. I would also note that one of the things that we are also doing is creating an ombuds-like role in case people are having concerns about the placement, concerns with their supervisor. We are creating an email, a phone number that they can call in. We've got a person assigned to that role who will hear from the provisional license lawyer or the supervisor, frankly, of problems that are having, see if these are things that we can help resolve. If we can't, then maybe, see if it's something that we need to direct the provisionally licensed lawyer or the supervisor to assist them in filing a complaint against the attorney, if it's the supervisor, with our Office of Chief Trial Counsel. Potentially, see if we can hook them up with a local or affinity bar to find a different supervisor, something like that. So we are thinking about how to address concerns with the placement to the best of our ability within our resources.
Yeah, because I imagine that it could be something that is used across multiple other pathways to licensure, or even for just new attorneys and their supervisors. I think that there's a gap in education for supervisors of even new attorneys, first-year associates, because they're not getting, it's hard to become an attorney and then just get dumped in and figure out how to litigate a case and then have a supervisor who doesn't know how to be a supervisor. So it's something that we might just be able to use both. I think even if we frame it as an MCLE, as a money, a money contributor, because people can pay for that MCLE to learn how to be a better supervisor to even new attorneys or pathway PLL students. So I think it can be, edited or moved to make it really productive for both our PLLs and also for new attorneys.
Ms. Peak?
So I will just echo what Ashley said, because those were the two main points I wanted to raise. Like, regardless of whether we proceed with the subcommittee, I do think this is an important endeavor. And I understand that there are probably like COAF and other orgs that are doing things, but as the entity that's governing the bar, I do think it is important for us to have some kind of a toolkit or whatever that we are providing to not only these supervising attorneys, but as Ashley was noting, just people that are supervising first and second year attorneys. Because I will recall my first couple years out, I was with people that were supervising me and insisted they were mentoring me. And I'm like, all you do is, give me tasks, which I need, and then tell me old stories about court, which is cool. But like mentorship and developing good quality attorneys that are going to represent the people in California are two different things. And so to the extent that we could develop a framework and guidance to a lot of attorneys for that, and especially in the PLL context, considering that the demographics are largely very different between like the people that are going through PLL and a lot of the people that might be supervising them. And then lastly, to Ashley's other point, in that this is useful in, other aspects of us administering the bar. And as we're considering how to redo the bar and maybe transition away from exclusively a bar exam and maybe some other more practical ways to assess minimum competency, we do need to start thinking about that and be proactive so that we have some kind of things in place as we move towards those goals.
So outside of Rule 9.49, do we have any policies, procedures setting forth what a supervisor should or should not do outside of Rule 9.49 that are
No.
published?
It's just the rule of court.
Yeah, that's sort of okay, noted.
Julie.
Oh, thank Ms. Smith?
I would just like to comment that I agree with, having more training and resources available to supervising attorneys. I think it's maybe something also we can consider for the law office study program. I think that might be useful for those attorneys as well. And that's a permanent program to kind of have more resources, for any kind of supervising attorneys, across different programs.
Thank you. Any other comments?
Have we had any issues that we can talk about publicly?
Well, I think in the joint meeting, certain statistics were reported back to us.
How many people succeed?
Yeah, and how many people actually had issues ranging from compensation to potential harassment, things of like. And so, and this is why I think a subcommittee would be potentially useful to at least one, enforce standards and rules, but also to receive complaint and the like. But again, this is certainly something that is worth additional discussions. I don't know we can actually make a decision today one way or another, but I do like the lively discussions that we are having now. So Dr. Bull,
Mr. Chairman, if I could
Yes,
come
Mr.
real quick,
Bull, go ahead.
thanks. Thank you, Chair. I think from the level of discussion being had today, I think it makes sense to support a subcommittee to kind of house these discussions and find a pathway that we either streamline these communications, these ideas, and have some level of reporting. Because the PLP program has been very essential tool for people to achieve their licensure. And so I'm supportive of it. I have a great deal of respect for Dr. Bolton, and I would definitely be supportive if we could move forward today.
So I would, I think you all feel like we do everything in our power to support the committee. I have a strong concern about our ability to provide staff resources to this effort, especially between now and July, when we will be having significant conversations and doing significant exploration and research on the bar exam of the future, what it is we are going to be proposing, developing the cost-benefit analysis. I don't know how much staff resources we're really going to be able to devote to this issue between now and July. And that's my concern. I don't want to create a subcommittee that we cannot meet your expectations in providing the staff support to.
I wonder, Dr. Bolton, would it be appropriate maybe to table this? Would it be appropriate to maybe table this for some more discussion so we can locate or identify if there are resources to staff this?
But thank you for bringing this up. This is certainly a very important topic, and that is worth additional discussions. Thank you.
Do we need a motion to table this? Or?
I don't think we do. Do we need a motion to table this, Donna or Jean?
No, we're okay.
Okay. With that, let's move on to agenda item 1.3, which is the, pardon me. 2.1, which is the approval of June 20th, 2025 open session minutes. Do I have a motion?
I'll move.
Moved by Mr. Yokelson. Any second?
Second.
Thank you, Dr. Bolton. Any additional discussions?
Yeah, these were the minutes that we found a typo in the staff report for agenda item 4.4, action on major change, teach classes more than 55 miles from campus, the colleges of law. The resolution that was approved used the incorrect name, the College of Law. And as a result, the minutes reflect that language. So we'd like to request that the minutes be amended to correct the name to the Colleges of Law by adding S to college.
So moved.
Thank you. Dr. Bolton, is that okay with you? The amendment. Any additional comments? Here are none. Ms. McFarland, please take roll.
Bolton,
Dr. Bolton?
Yes.
Cow, not present. Gongora,
Yes.
Kaplan,
Yes.
Kramer,
Yes.
Lawrence, not present. Lynn, not present. Macy-Walla, Montgomery,
Yes.
Peak,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Reyna,
Abstain. This is for the June 20th meeting, right, minutes?
correct.
Yeah, abstain. Thanks.
Reyes,
Yes.
Yokelson,
Yes.
Chan.
Yes.
With 11 yeses and 0 nos, the motion passes.
Thank you. Next item, consented calendar. 3.1, approval of report to the Supreme Court on the February 2025 California bar examination. Do you want to go through all three, or?
I think you take all three.
Yeah, and also 3.2, which is the report on administrative updates regarding law schools, and finally 3.3, which is the action on acquiescence to non-JD program to colleges of law. Any additional comments, questions from the committee? As a reminder, consent calendar is voted on and approved as an omnibus item, meaning one vote for the entire calendar unless a member decides to pull something off the consent calendar. So this is probably a good time if anyone wants to put anything out. Hearing none, I need a motion.
I'll second. Ashley.
I'm sorry, who made the motion? Oh, thank you. Moved by Justice Macedonia, second by Ms. Silva Guzman. Any additional comments or questions? Hearing none, Ms. McFarland, please take roll.
Bolton,
Yes.
Cow, not present. Gongora,
Yes.
Kaplan,
Yes.
Kramer,
Yes.
Lawrence, not present. Lynn, not present. Macy-Walla,
Yes.
Montgomery,
Yes.
Peak,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Reyna,
Yes.
Reyes,
Yes.
Yokelson,
Yes.
Chan.
Yes.
With 13 yeses and 0 nos, the motion passes.
Thank you. Next on the agenda is item 4.1, which is the update, discussion, and possible action related to February 2025 bar examination, July 2025 bar examination. This item is being presented, I believe, by Audrey.
That's correct.
Floor is yours.
Thank you. So I didn't post the same PowerPoint I gave last week. That's posted to last week's meeting because there weren't any significant updates between last week and this week about February and July 25. But I did want to give the committee a small update, which is we have been getting requests for scoring adjustments and imputations from the July 2025 exam. So last week I talked about there were typical one-off issues at exam sites, including issues where someone had to switch to a handwriting packet because their laptop had a malfunction, or after the exam when they were attempting to upload their answer files, their computer was unable to upload those files. And if we don't have files to grade, then they can't receive a grade on those essays. So we have had applicants writing in through the applicant portal or to Donna and Erica, the interim ED, directly asking for scoring adjustments and imputation. I just wanted to bring that up to you so you know, based on some of the activities that happened with February, we are getting requests like that for the committee to consider for July. But they are nothing systemic, nothing where it affected a wide swath of applicants, just a couple here and there that said they had issues, mostly with their technology.
For clarification, these are issues that are a result of the applicant's technology,
Right.
Not anything from the committee or from the test application.
Right.
Is that correct?
So the applicants signed a declaration about using their own laptop when they elect to use a laptop to submit their answers and write their answers in. And it's about their issues with their laptop in general. There were some applicants who have written in saying they lost time for various reasons because of the way the administration went at one of our standard sites, but for the most part, asking about their laptop.
I can't imagine, again, the frustration and disappointment that an applicant has when at the end of the exam, they find that for whatever reason, they cannot upload their results and get a grade. In this case, because it's not anything from the committee's standpoint, I'm afraid we cannot offer the remedies that are asked for. But I do want to make it clear that if the applicant is able to recover the data in this particular case in a reasonable amount of time and can otherwise lay a foundation that it hasn't been modified or so forth, that it will be graded. Is that correct?
Yes, and we've been working, if anyone who's written in saying to give extensions for how long they can upload their answer files, wanting to be flexible if they can recover anything from their computers.
And I do also just want to be clear, as Audrey mentioned, that there are requests that relate to having lost time, or a variety of other issues where people are requesting scoring adjustments. Staff have been responding to those individuals and saying that the February exam was unprecedented. There were very unique circumstances. I guess you can't say that. There were unique circumstances with the February 2025 bar exam. There are unfortunately issues that happen at every bar exam that cause challenges for individual applicants. And we have not historically and cannot be in a position where we are applying individual scoring adjustments to applicants based on the unique circumstances that they faced. And so we wanted to make sure to share with the committee that those are the communications that we've been having with applicants. And I share with Alan the understanding of the utter devastation that people face, especially when they get to the end and their laptop dies and they're unable to upload answers. But that is just something that we just can't be in a position to address those on a one-off basis. There were widespread systemic issues for the February exam And that's why the committee and the board recommended and the court adopted the particular scoring adjustments and the imputations that they did.
Have we lately looked into the robustness of the pre-testing software, I guess, or anyway, the way applicants can log in and run a test to make sure their system is up to the minimum requirements?
And ExamSoft is going to be presenting in exactly an hour, and you can ask some more questions when they do the demo, but there's like a speed test you can do about your device or testing your device. And then we have the required mock exam to go through and do a mock question, a mock answer, so they can practice before the exam begins.
Okay, and you feel it's pretty robust?
Yes, for the application that we're using it for, which is largely just an answer window, typing it in and then submitting a file.
Yeah. Yeah, I think anything we do in the future that requires a continuous uninterrupted internet connection is going to be really risky.
Are the applicants sort of putting the blame on the software or on the hardware of the computer?
I think it's more about the device itself, so more about the hardware. Something, if they had to switch to handwriting, something was happening in the moment. And we have technicians there, ExamSoft technicians, or and they couldn't reboot, usually a hard reboot, and then people can get back in. But if not, then on the spot, you switch to handwriting, which is a remedy in and of itself, right? So that does happen, but obviously people were upset that they couldn't type, and that's the manner that they practice for the bar exam, right? And then the upload issue, I think, is definitely related to what the laptop that they were using.
In that case, ExamSoft wouldn't be able to do anything if it's a hardware problem, right? If a software problem makes sense, their interface, but another issue is, I mean, is this a case of first impression? Meaning, I mean, I would think we have had situations like this in the past.
Yes.
And in the past, have we given I think I know the answer to that, but just for the benefit of the committee, how did we treat those cases in the past?
No, we don't do one-off scoring adjustments. With the committee's policy for grading reconsideration was narrowed over the past 5 years, which is to just be about clerical error. So.
Yeah, and this is written into the policy as well.
Yes.
It's very unfortunate, and we're sympathetic. Unfortunately, it doesn't seem like there's anything that the committee is able to do or afford. But please continue to work through these cases and update the committee. In the meantime, any additional comments or questions from the members of the committee? Okay, hearing none. Thank you, Audrey.
Thank you.
We've now moved on to agenda item 4.2, which is the action amendments to Rule 9.42 of the Rules of Court, State Bar Rules 3.1 to 3.11, and 4.29 and Appendix A, related to the practical training of law students in Law Office Study Program. Return from public comments, request to approve amendments and recommend adoption by the board, subject to approval by the California Supreme Court as appropriate. We have a presentation led by Ms. Clark and Ms. Christina Dole. Please take it away.
Hi there, everyone. I am presenting on 4.2. You can go ahead and go to the next slide. As a reminder for the entire committee, we have seen the law office study and the practical training of law students rules revisions previously. Most recently, we had sent the rules revisions out for public comment. We have now received the public comments back. For the newer members on the committee, as a reminder, the PTLS program allows law students to get practical experience while studying law. The proposed rule amendments change the name of the practical training of law students to the Certified Law Student Program. That is going to align with our current rules that call it the Certified Law Students Program. And the proposed changes also expand the program to allow law office study and LLM students to participate as well. But we've removed references to participants being able to study in a law office chamber, or excuse me, in a judge's chamber for potential conflicts of interest. On the chart at the bottom, if you can see the chart at the bottom, we had 11 public comments total. 8 of the public commenters agreed with the proposed changes. 2 no positions and 1 person disagreed, but they did not leave any comments, so we're not sure why they selected those positions. The Law Office Study Program is an alternative pathway to legal education that allows individuals to complete 4 years of study in a law office or judge's chamber rather than traditional law school. The proposed changes set clearer guidelines for participation, give more flexibility by allowing a portion of remote study, and sets more structured oversight through reporting and attestation requirements. For this public comment period, we had 18 public comments, which are detailed in attachment B for you all. Those that selected no position, again, did not give a reason for their selection. We received some mixed reactions to the proposed changes, with some public commenters expressing concerns about the impact of the program integrity and success rate, while others supported the modernization and increased access to the legal profession. We believe that by allowing a portion of the supervised hours to be completed remotely offers more flexibility to the student and the supervisor, and also ensures that the student is adequately supervised. We are asking the CBE to recommend to the Board of Trustees to adopt the proposed changes and transmit them to the Supreme Court for review and approval. But I wanted to pause here as we put the motion up and see if there's any questions, comments, or if Bethany Peak and Ashley Silva Guzman, who also worked on these rules, wanted to add anything.
No additions from, oh, that sounded really quiet. No additions for me, but I'm really excited about these rule changes. So hopefully everyone's in agreement, or we can answer any questions if not.
And do we have a motion then?
Yeah, we need a motion.
I'll make the motion. Ashley Silva Guzman.
So moved.
I'll second.
Second by Justice Misuala. Any additional discussions? Hearing none. Floor is yours. Kevin.
Bolton,
Yes.
Cow, not present. Gongora,
Yes.
Kaplan,
Yes.
Kramer,
Yes.
Lawrence, not present. Lynn, not present. Masiwala,
Yes.
Montgomery,
Yes.
Peak, not present. Silva Guzman,
Present, or sorry, yes. I was like, I am present.
Smith,
Yes.
Reyna,
Yes.
Reyes,
Yes.
Yokelson,
Yes.
Chan.
Yes.
With 12 yeses and 0 nos, the motion passes.
Thank you. Next up is agenda item 4.3, which is the approval of revisions to policies related to selection of content validation panelists and subject matter experts. We have a presentation by Cody.
Thank you very much, Chair. I don't have a presentation. I'll keep this pretty brief. The committee likely remembers in June 2025, our last meeting, we brought to the committee a policy on the recruitment and selection of content validation panelists who were set to review multiple choice questions being developed for the California bar exam, as well as a separate policy to allow for the selection of subject matter experts whose role was to purely review those multiple choice questions for their legal accuracy. Since that meeting, we've met with our exam development and grading team, and what we found was that they feel their services are best focused around their current task, which is selection, review, and revising our essays that are developed internally. So what we would like is to adopt a set of minor revisions to these policies to allow content validation panelists to also review essay questions that are being developed by our vendor, and also to allow subject matter experts to take on ad hoc expert review tasks on an as-needed basis. The reason for the value in having these content validation panelists of course, is to ensure that we can provide back to our vendor timely feedback about drafts that are being developed and ensure that those questions go through a similar review process for their quality as we are planning for the multiple choice questions. So the staff report really identifies that the content validation panels are likely to be structured and facilitated in a way that looks a lot like the panels that we have already conducted for multiple choice questions. And as noted in the staff report, the kinds of tasks we are imagining subject matter experts taking on an as-needed basis would be things like reviewing the study guide materials and other ad hoc tasks in which an additional expert opinion would be valuable. The last thing I'll note, just again to keep things brief, we've added at the end of the staff report a fiscal impact. I just wanted to underline we've estimated the cost of essay review by content validation panels to be about $85,000 annually, but I wanted to underline our note that the cost in doing so is really a shift from expenses that would have been incurred in paying the exam development team to do similar tasks. So that is the estimated cost, but these are not new expenses. This is a shift from exam development and grading team costs to content validation costs. So with that, I'm happy to take any questions, but we have a resolution for the committee to approve these small policy amendments.
Can we put it up just to see what the resolution is?
I'm not logged in.
Oh, okay.
Yeah, could you? Oh, thank you, Sharon. Perfect. I'm sorry for that.
I think we can make the screen bigger. Thank you, Donna.
So that resolution's really just broken into two parts because the committee adopted in June 2025 two policies, one for content validation panelists and the other for subject matter experts. The first piece of this resolution is adopting the modifications to the policy for content validation panelists, which is attachment A in the staff report. And the second piece is approving the modifications to the policy for subject matter experts.
So in the case of essays or performance tests, they would be evaluating, I guess, the model answer that the vendor's providing along with the essay question?
So for the essay, what will be under review is of course, the question text, which they will assess under the same criteria that multiple choice questions were assessed under, whether it's free of bias, it aligns stylistically with our historic questions, and a number of other criteria. What they'll also be reviewing would be the legal analysis that comes with those questions, which is often also referred to as a model answer. This is really just an in-depth explanation about the legal principles raised by the question. But as you recall, the panelists aren't tasked with rewriting any of this material. They're really meant to just provide independent judgment on those narrow criteria. That goes back to the vendor and modifications are made accordingly.
But all of the deliverables that come from the vendor, the answer, the question itself, the model answer outline, the legal analysis, all of that would be reviewed by the content validation panelists and they would also be looking at sort of the instructions and making sure that there aren't, red herrings buried in there, unnecessary facts buried, all of the things that the EDGE team ultimately looks for. They'll be doing that sort of in addition to looking for bias and stylistic, all of those issues will be evaluated by the content validation panelists. So we do have sort of an immediate back and forth with the vendor to get the questions in as good a shape as we can. So when the EDGE team does nominate the question to put on an exam, the question it is in as close a form to being ready to be pre-tested as it can be.
So currently we get our essay questions from, basically law professors who submit them. Are we shutting down that pipeline, or are we simply using the vendor to have a more consistent, reliable source of new questions?
So I think the plan is shutting down that pipeline, though I would note that a large majority of the drafters that the vendor uses are also law faculty.
In the context, oh, Judge Reyna.
Yeah, hi. I was kind of along the lines of what Paul just asked. I was just wondering, so is there going to be like a bank of questions? My understanding of how the testing, these questions essays worked with the Edge team was that they had like a bank, and then they would have other folks test them to see how they were doing, you know, and maybe we'd modify them after some time. Is that still going to happen, where we're going to have with our vendor a whole bunch of possible essay questions, or are they just going to go test by test? I'm kind of curious how it's changing the Edge team's role in this.
Yeah, that's a great question, Judge Reyna. The actual intention of this is to not change the Edge team's work. So everything that's being contemplated by this content validation panel happens prior to questions being placed in the bank. Once it goes into the item bank, from there, the exam development and grading team will continue to do their work as they always have, which means they'll go to the bank, they can nominate questions out of the bank, then they refine, pre-test, and ultimately make recommendations for selection for the questions. So everything after an item being entered into the bank remains the same. So it really is that the vendor is just replacing the faculty members that we previously solicited to submit questions. As Donna mentioned, the adding of a content validation panel, though, ensures that while we have the vendor, we can make the most of that time to refine the drafts and bring them to as close to a final form as possible. But that does not prevent the Edge team from continuing to refine those questions during pre-testing and their normal editing process after the questions are placed in the bank and later on when they're nominated and reviewed again.
And we do have a pretty healthy bank of questions right now from all of the submissions that we have gotten over the years. And the intention here is that this will beef up the bank of questions and ensure we have more questions in each of the subject areas that we might want to test. And so as Cody said, that the Edge team work will continue to be what the Edge team work has been with regard to identifying the questions that they'd like to nominate for upcoming exams for the year, and then doing the work on the questions once they pull it out of the bank.
So just a quick question on the vendors in terms of how we work with them. Are they contracted to provide a certain number of essay questions or multiple choice questions in any given cycle to contribute to the bank, I imagine? Is that right?
Yes. Yes.
In the context of multiple choices, once we get those questions from Kaplan, who do we use to vet them?
Question. What is the difference of a benefit in using the vendors instead of the law professors? What's the benefit of doing that?
Go ahead, please.
Yeah, so one of the things is to increase the volume, increase the amount of questions that we are getting in the bank. But also, I would point out, this is part of what was contracted for last year. And so this is part of the expected delivery from the vendor. And so what we are doing is trying to make sure that we are making the best use of the materials that the vendor is going to provide us. And as Cody has said a couple of times, making the best use of the Edge team and their skill set and their resources, and not, as we had originally imagined, putting the Edge team in the role of taking the questions straight from the vendor, doing the work up front before it went into the bank. That's not the best use of the Edge team based on the conversations that we've had with the Edge team itself. And so we are sort of putting the content validation panel sort of in between, so we can ensure that we're getting the best value for the dollars that we have spent on this contract by making sure that we have the iterative process between the content validation panel and the vendor. We are engaged in iterative process, so they are giving us questions that are to our satisfaction. And so that's why we are adding this process in.
Going back to my question about multiple choices, who vet them?
Vet them meaning when we get the delivery of the initial batch.
Right.
Well, they too go through the content validation process, and we've already facilitated some content validation panels for the initial batches of questions. As Donna just mentioned, that process is iterative, and we can have content validation panels review multiple choice questions as many times as we want, providing feedback to the vendors until they meet our requirements. So we have panels, but a question can go through multiple rounds of panel review if necessary.
And will the subject matter experts be also involved in that process? Or is this only within the province of the content validation panelists?
Subject matter experts are involved in the review of multiple choice questions as sort of the last stop of review. They're not part of the content validation panels per se, in the sense that they aren't providing feedback about the style and substance content of the question. In a sense, they are only doing a final review for the legal accuracy. So questions will be reviewed iteratively through content validation panels. And once they've reached a level of satisfaction, then they'll go to the subject matter experts for review. That step as well can also be iterative. So if there's a issue with the legal accuracy of a question and it's modified and returned back to the subject matter experts and it's not satisfactory, resolved in a satisfactory way, it can also be revised again.
What I feel like is, again, I know there are a lot of moving parts. What I feel like would be useful to the committee would be some kind of a flow chart, just explaining about how we start from, let's say, getting the initial batch to putting things in the bank. I mean, something where we could visualize the process. I feel like this is something that all the members would benefit from, just because we have a lot of members rotating in and out, and I'm guessing these questions will come back again and again. So if I may ask, maybe for the next meeting, again, subject to the bandwidth of the staff, is to prepare something as simple as a flow chart, illustrating how the multiple choices and essays are drafted all the way up down to the goalpost, meaning it gets selected and ultimately decided and approved by the committee. Would that be something you're able to give us?
Yeah, certainly. This is something kind of been developed already for internal purposes as well as we're developing these processes. So we can think about what to bring to the committee to understand it as well.
Awesome. Again, that's because I'm hearing from Judge Reyna, some of the questions seem like we know the answer to, but certainly will help just to hone in on the idea about the process and the flow. Any other questions from anyone else? Hearing none, we need a motion.
I'll move.
Moved by Mr. Yokelson,
I'll second. Ashley?
second by Ms. Silva Guzman. Any additional discussions or comments? Hearing none, we need a motion. Devin, please take roll.
Bolton?
Yes.
Cow, not present. Gongora?
Yes.
Kaplan?
Yes.
Kramer?
Yes.
Lawrence? Not present. Lynn? Not present. Masiwala?
Yes.
Montgomery?
Yes.
Peak?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Reyna?
Yes.
Reyes?
Yes.
Yokelson?
Yes.
Chan?
Yes.
With 13 yeses and 0 nos, the motion passes.
I think this is a good breaking point, so let's take a 5-minute bio break, and we will resume at roughly 10:30. Thank you. Next agenda item is 4.4, which is discussion of 2024 California Accredited and Unaccredited Law School Performance Report. This item is being presented by Ms. Chavez and Ms. Leonard. Give them a second.
Devin, can you share the slide deck, please? Or Sharon?
While Devin's preparing. Is feedback okay, Tom? While Devin's preparing the slides. Okay, let's try this again.
Apology, we're experiencing technical difficulties. We are swapping microphone. Hopefully this works.
Okay, how's that, everyone?
Perfect.
Okay, great. Well, now we have the slides, so let's talk about this background while we have them. So welcome everyone today. I'm Natalie Leonard. I work with Educational Standards and Admissions, and I'm here with Lisa Chavez.
Hi, good morning, everyone.
Also working with us through admissions and a liaison to the Office of Research and Statistics. So today we'll be talking about key findings from the 2024 California Accredited and Unaccredited Law School Performance Report. This report is based in the materials that schools provide each year in their annual periodic compliance report. We put together highlights to provide you with background and comparisons of performance. We've got highlights in our presentation today, and then you have a further appendix in your attachment A that will give further detail generally on a school-by-school basis. So let's go to the next slide. And just one more. Perfect. So we talked about this being an overview of what's been going on in the accredited and unaccredited space this year. These are the two types of schools that the State Bar regulates here in California. Of course, there are also ABA-approved schools under the jurisdiction of the ABA Council on this section of regulation of the legal profession and admission to the law. Those are not included in this report. Are we still good? Okay. Okay, great. Thank you. So let's go to the next slide. Thank you. So we talked about the two types of schools that will be a part of this report, and the key performance measures that we've chosen are only a subset of what you will find and what staff reviews in the annual report each year, but this should give you a good overview about what is going on with the schools. I understand we have some newer members here in the committee, and we welcome everyone, particularly the new members, to ask any questions you may have about the data we're going to share.
Okay, let's move on. Can you go to the next slide, Evan, please? Okay, so what you see here is an overview of the number of schools over time. The bar on the left is from 2014, and we chose that so we can have a nice comparison to what was going on a decade ago. And one thing that really struck us was that, back in 2014, the State Bar at that time was regulating 38 schools, and the majority of them were unaccredited. When you take a look at the slides, please note that throughout these slides, whenever you see a blue, that's the CALs, and the teal are for the data for the unaccredited. So that's so you can orient yourself. As you go through all the slides, when you see those different colors, those represent the different schools. And if you skip ahead all the way to 2024, we're down to regulating 26 schools, and the majority are CALs. At this point, CALs are now enrolling the majority of students. Back in 2014, both types of schools, when you combine them together, were enrolling over 2,000 students. And here we are in 2024. At this point, the majority of students enrolled in our two different types of schools are enrolled at the CALs. In just the last year alone, the CALs saw as a group a 9% increase in enrollment. And at this point, they have reached an all-time high of nearly 5,000 students. And in contrast, at the unaccredited schools, in the last 2 years alone, most schools experience a decline in enrollment, and you'll see that in the report in the appendix tables. And that now at this point, enrollment at our unaccredited schools has reached a record low of 476 students with an average of 53 students per school.
And Lisa, could I provide a little context?
Sure.
Thank you for your patience with the microphone. We weren't planning to talk about it this way. Part of the reason that you're seeing that trend is that previously Cal schools were only able to offer fixed facility programs. And then starting in 2019, this committee laid the groundwork such that CALs could provide not only fixed facility programs, but also distance learning programs. So they have much more flexibility now. And as a result, a number of unaccredited schools chose to apply for and earn accreditation. In addition, we've seen several schools that were previously ABA approved decide to become California regulated instead. So that's a little bit of the background. We also did see some voluntary closures generally in the unaccredited space based on just a shift in priorities or in some cases the passing of the owners.
And then finally, the report shows that the unaccredited schools remain more affordable than the CALs on average. Okay, next slide, please. So here's information on the racial, ethnic, and gender diversity of our different types of schools. Here on the left, you'll see percent enrollment of the people of color and women at the different types of schools. And in general, people of color and women remain either the majority or the largest group of JD enrollment at the CALs and unaccredited schools, so no difference there. And in 2024, these are the slides on the figures on the right. I mean, once you look at individual racial ethnic groups, you see that white students are the largest group of students at both CALs and the unaccredited schools. When you look at for Latino students, they're the second largest group at the CALs, while Black students are the second largest group at the unaccredited schools. And then we're really committed to exploring all data by the intersection of race, ethnicity, and gender identity. And what we found was that white women, Latinas, and white men were the three largest groups at both the CALs and unaccredited schools, and that's that chart there on the right. Next slide, please. So we now have 3 years of attrition data using a cohort model of exploring attrition, and that is explained in the methodology of the report. And what you see here is that really there's disparities in first-year attrition rates across the two different types of schools and among demographic groups. So ultimately, and what we mean by first-year attrition is like if you look at a cohort of students who start their JD programs, what percent leave before the end of the next, and they don't return for the next year. So ultimately, first-year attrition rates are consistently higher at the unaccredited schools. For both types of schools, students are more likely to experience first-year attrition for non-academic reasons. So we have our schools report to us, like the total number of students who have tried it and whether it was for an academic reason or a non-academic reason. What's interesting is that between 2023 and 2024, first-year attrition rates declined at the CALs, but however, they have increased at the unaccredited schools. So like I said, we're really trying to leverage at this point the 3 years of data that we have. And we found that racial disparities, that we identified in last year's report are also persisting in 2024. At the CALs, Black and American Indian students have attrition rates of over 50%. And at the unaccredited schools, Latino, Black, and Asian students had attrition rates of 63% and higher. So those are high. When I name those numbers, that's because those are higher than the total students as a whole. Okay, next slide, please. We're also committed to reporting out on a regular basis performance on the first-year law students exam by our different types of schools. Here we explore the unaccredited by the three different modalities, whether it's a fixed facility, a distance learning, or correspondence school. And ultimately, well, the good news is that students at the CALs and all three types of unaccredited schools experience higher pass rates between 2023 and 2024. And I believe, Natalie, there's a reason for that. There was a change in the type of testing.
Well, the format did change. So previously it was a combination The format did change. Previously, it was a combination of essay and multiple choice. The committee moved to change the format to multiple choice only. So we are still observing at this point, and I understand that the exam development team and grading teams will bring back an analysis of that change to the Committee of Bar Examiners in the future.
And we did explore just the different types, and ultimately the CALS and the unaccredited correspondence schools saw the biggest improvements in pass rates. Okay, the next slide, please. So another way to think about performance is ultimately the number of JDs awarded. And as you can see here, we have data we're presenting data here for 3 years. And ultimately what still remains in place is that the CALs are awarding over 90% of all the JDs that are produced across these two different types of schools. In particular, the CALs, they awarded 589 JDs, which was up from 492 the year before. We have data that people of color earn 50% and women earn 60% of those JDs. However, at the unaccredited schools, they awarded 56 JDs, which is a decline from the previous year of 83. And here, people of color earn 39% of those JDs, and women earn 52%. And I don't have a chart on this, but we also analyzed like the actual JDs for the intersection of race and gender. And we saw that white men, white women, and Latinas, those three groups alone combined earned 50% or more of all JDs at both the CALS and unaccredited schools. Okay, last slide, please. So here we have performance of the California bar exam for our two different types of schools. And what we notice is that the gap in the pass rate continues to grow. So if you look over in 2014, the gap between our two different types of schools was just 8 percentage points. That gap narrowed over time, and then it began to increase in 2021, and it's now at this point, it's 11 percentage points difference, whereas with 24% pass rate for the CALs and 13% for the unaccredited schools. And racial disparities and disparities in test taker status persisted in 2024, where first-time test takers continue to have higher pass rates than repeaters at both types of schools. And then we have information here about for the CALs among the first-time test takers, Black and Latino students had the lowest pass rates.
Is that the 5-year pass rate basically, something, or just the first time?
This is just, so the chart is for pass rates for all test takers for just the July exam.
Oh, okay.
Yes. Okay, so thank you very much, and we're happy to entertain any questions you have about the report or the presentation that we gave you.
So one of the things that that we were talking about, staff was talking about internally, is now that we have presented this report 3 years in a row, you've got 3 years of data. At this time, it might make sense for for us to start looking at whether, right? Let's explore whether we should be developing any performance metrics. And now that we're seeing what the data is looking like, and so that might be something that we could. That the chair and the vice chair of Ed Standards can work with staff, explore whether there should be any metrics. If so, present those to CS bars, take the recommendation from the chair and vice chair and CS bars, and present that back to the committee. The answer may be no. The answer may be yes. But it seems like now that we've done this for 3 years in a row and we've got multiple years of data on this, it might be. Looking at the data closely might be suggestive to you all that there are some targets that we would want to expect the CALS or the unaccredited schools to meet.
Well, Vince and I, chair and vice chair of the Ed Standards Committee, have been working with Natalie for a while now. It's kind of been put on the back burner because of the recent difficulties, but on revising, for instance, the unaccredited school rules, or the registered school rules, whatever you want to call them. And two things we have been discussing is trying to describe an acceptable level of attrition. And then also we've talked as a group, I think here, a little bit about having a minimum bar passage rate standard as well for those schools. So those are two things that I think are already under discussion. And I think I'll speak for Vince. I think we'd be happy to continue that work. And if maybe later today, when we talk about the work plan, we could formally put it on there. I'd be curious to know if there's any other metrics that people are interested in exploring. None really come to me at this point. First year law exam passage rates might be another aspect, but that's also basically leads to attrition, because if you never pass the first year exam, you don't make it out of the JD, you never get a JD. So maybe those are related enough that just measuring attrition by whatever means is appropriate would take care of that without having separate standards. And then we have to talk about, well, are these hard and fast standards? Minimum pass rate might be on the bar exam. Attrition, at least in my view, is a little more squishy. But it's, we know 100% attrition, that would be a problem, I would presume. And somewhere between that and zero is maybe a line where we start to say, well, we need to put this school under a microscope and see what's going on, because there's too much attrition. But anyway, we're glad to work on it. Have I committed you to too much, Vince?
No,
Okay.
in fact, I wanted to-
Assuming that we're reappointed as the leaders of that subcommittee.
I just wanted to add, it's very concerning, the Black and Latino low pass rates. And so it speaks to a lot of things, not only what Paul was saying, but the individual schools, what kind of academic support they're able to provide to people, and how early in the process do they recognize that that could be an issue for particular students.
I think also it's very helpful to have this data for additional reasons. Sometimes something shows up that you might not have thought about. So for example, when we saw that a number of unaccredited schools had closed, we've been able to partner with the California Lawyers Association to create a mentorship and motivation program through that organization. So each of these applicants that have graduated from a school that has now closed may not have the alumni support from that school, but they can partner with the California Lawyers Association. This is the first bar exam where that's been in place, and we're eager to see how things have gone for those applicants. So there can be not only tracking information, but also supportive programming as well.
Mr. Kaplan?
Yes. Any explanation for the disparity that emerged in the last 5 years between accredited and the CALs?
As to which aspect, or I can talk about it generally?
Well, I noticed the chart with the passage rates, how it plunged. They tracked pretty closely for a number of years, and then boom, all of a sudden the unaccredited dropped.
Thanks, Larry. A couple of things. The first thing is that a number of schools, frankly, just prepared themselves for a track to accreditation, and those schools accredited starting in 2020, and it was some time before they had a larger population taking the bar exam under their accredited status. They had teach out students in the unaccredited. So part of that is some of the top performers have moved on to accreditation. And the other part, we're working with the various schools. Today, you'll see California School of Law. We have a few suggestions for that particular school, for example. So I think that will give you a more detailed type of insight today.
Now, Lisa, this is a relatively smaller sample. So does that explain some of the variability from exam to exam of the results? Yeah. Can you?
It's actually real people, but it is a small number. And we do have those numbers in the appendix, I believe. You could actually see the number of people that took the exams, I think.
So the curve is going to, the curve can wave more because you don't have a much bigger group of data points.
Well, the thing is that they're actual people. So they are who they are. The number of test takers. I'm not sure if that would explain this variability necessarily because they are. But I can think about that some more. Thank you.
Okay.
Thanks. Sure. That's not something we've explored yet, but we can see about that.
I think part of what you're looking at too is what is the cut of the pass rate that's described. So generally this pass rate here is only amongst those that do go forward, graduate, become applicants and take the bar exam. So you could have a school with a very high pass rate against a small pool of applicants, say starting with 100, just a few taking the bar exam, 3 out of 4 passing, 75% pass rate. So that could be something we could look at further and figure out ways to represent that to you easily.
It occurs to me plotting the ABA schools on some of these charts would be educational as well in the future.
That's something that we could add. And just to give you an idea of what the ABA benchmark is, I don't think there's an expectation that this would be the same benchmark for the CALs, but once a school reaches 20% total attrition for a 3-year period, that is a presumed instance in which the council will do an inquiry with the school.
Any additional questions or comments? We have a special session set at 11, so unless we have additional comments, Chavez?
I was just looking at the number of test takers, so that's in table A15 in the appendix. And so just to give you a context, in July 2024, there were 979 test takers from the CALs compared to 185 test takers from the unaccredited. And I looked over the last 3 years, it was like 183 to 224 to 185. So not much variability, but it's certainly a smaller number than the number of test takers from the CALs for our bar exam.
Thank you. Seeing no more hands and questions, thank you for your time. Thank you, Ms. Chavez and Ms. Leonard. We will now go into agenda item 4.8. We're going to jump around because we have a special session to discuss ExamSoft. We will have a presentation by ExamSoft vendor.
We're just going to promote Cindy Nagel and Marcina Batsweska from ExamSoft now so they can present.
And just for members for a little context, because there was a public comment that suggested a different purpose for this presentation. This is the first in a series of presentations, the next several of which will likely come to the Exam Administration Subcommittee. But this is the first in a series of presentations to bring to the committee an exploration of the different platforms that are out there for use for delivery of the bar exam. This does not represent, as the public commenter suggested, that we had made a selection for the next bar exam. This is to engage the committee on being informed on what the different platforms are, so the committee can assist in what the selection for future vendors would be.
Eric, Cindy, Mazana, thank you for joining us. The floor is yours.
Thank you. Thank you to the committee and to Audrey for inviting us. I'm going to go ahead and share my screen quickly here. A minute here. So. Okay, are you able to see my screen at this point?
Yes.
Okay, great. So I just wanted to take a quick moment to introduce Marzena and myself. We are 2/3 of what is called the bar team at ExamSoft. Marzena has been with the company for more than 15 years, and she is the resident expert on all things ExamSoft. She handles every detail related to preparing for and administering exams. She keeps internally all of us on track. She keeps our clients on track. She keeps me on track. She is certainly a vital part of the team. And then I come to ExamSoft with a background working in law school, in bar admissions, and in bar regulations. So I've been with the company for about 5 years now. So we'll just start right in. So what we wanted to talk with you today was just go over very briefly an overview of the testing experience using our software. But mainly we want to focus today on what applicants experience, both before the exam and when they use the software to take either a mock exam or their actual exam. So very briefly, kind of the exam cycle as we see it is within the software, we create an exam using questions. As I think Audrey pointed out earlier in the meeting, these are very general questions. They're not actual exam questions. We use it for bar exams, the software more like an electronic blue book. But we create the exams. The applicant will download those exams securely onto their device. They are encrypted. They're not able to access them until they receive the password to unencrypt them. Once they enter that password, their device is locked down. They are not able to access any other part of their device, so they can't see the internet or any notes they might have. All they can access is Examplify. They take the exam, they submit the exam, and their answer uploads to the server and to the portal so that your team can then extract those answers. And then after the exam, your team's able to see some reporting, and we provide some additional reporting on applicants based on their exam experience. So prior to the exam, applicants hear from us a number of times. We send them very detailed registration instructions. We send them multiple reminders, and they have support available to them 24/7 during the run-up to the exam and after the exam. So this is just an example of the registration email that we send to the applicants, and you can see it's got a lot of information on it. But there are two things that are key to it. One, we ask them to check the minimum system requirements to make sure their device is going to be compatible with Examplify. And second, we very strongly encourage them to take a mock exam so that they can see that their device is going to work with the software. Once they have received that email and followed those instructions, they come to this registration homepage where they can again see the instructions, and then they can enter their credentials so that they log on. Then the next screen they see will look like this. They do accept a disclaimer that affirms that they will complete all the required steps to register, that they've looked at the minimum system requirements, that if they have any issues while they take the mock exam or during the download process, that they'll contact us. And so they accept that disclaimer, and then they can download the software. So the next two screens that they see look like this. They select their jurisdiction, which in this case is State Bar of California, and then they again use their credentials to sign on to the application. And then this is what they next see. This is what we refer to as their dashboard. And you can see here, I have a completed exam from the July mock exam for this test account that we use. But there are exams that are already downloaded. And so to save a step for applicants, the exams automatically download once they open the software. Again, they sit there encrypted on the device. They're not able to open them until they have the password to unencrypt it. So once they've taken those steps, they receive a couple of confirmations. One is they receive a confirmation email that says, we received your registration. and confirm that you completed all those steps. And then for each exam that they download, the mock exam and any exam sessions, they'll receive separate emails saying you've successfully downloaded that exam. This is a quick look at what the mock exam or an exam looks like in the application. We're going to have a more in-depth demonstration using the actual software here shortly, but I just wanted to point out this is a question. It looks like it relates to spell check, but we walk through in the mock exam each of the features and steps on how to use the software. So then we get to exam day. So there are some important things for exam takers applicants to understand during the exam. They should, and we stress these many times throughout the process, but they shouldn't cut text. They take a chance that if they take an intervening step when they didn't mean to actually delete text and not immediately press undo, that they might lose that text. So that we only want them to delete text once it's pasted where they want it. But even more importantly, a lot of times exam takers kind of panic. Most issues can be resolved with a restart, whether it's before the exam and they are having trouble getting the software to start, or if it's during the exam, if for some reason it just stops. A restart will almost always fix the problem, and they will be taken to within 59 seconds of where they left off in the exam. And then another really important thing is that they shouldn't ever exit the exam while they're taking it, because you can't reopen it once you've submitted it. So after the exam, they will receive upload confirmations that their answers have been successfully submitted. Most exam sites do not have internet access. And so this is the screen that they will typically see. It gives them instructions to be sure to upload by their jurisdiction's deadline, and it allows them to return to the dashboard where it tells them how they need to go ahead once they connect to the internet and submit their exam. But once they do submit their exam, they get confirmation. They can have confirmation 3 ways. First, they'll see this upload complete, what we call the green screen. They also, when they return to their dashboard, will see a green check mark next to the exam that's been uploaded. And then they also receive a confirmation email for each of the exam answers that they have submitted. So after the exam, we continue to provide support to the CalBAR team. We provide a report of every applicant for each exam showing when they took their first and last keystroke, which I think is helpful to the team in looking to see if anyone has written over time, because these exams do not have a timer built into them because the proctors control when the exam starts and when it stops. This allows, and then we help them with tracking late uploads and sending other reminders to examinees who may not have uploaded. And then if they have questions about any particular exam or applicant's experience on exam day, we can conduct some additional investigation. So one of the ways we do that is through what we call the character count report and snapshots. And this is just a quick overview of what a snapshot report looks like. We take snapshots throughout the exam in the background. We take them every 10 minutes, but we also take one anytime an applicant cuts or deletes 500 or more characters, so that we can go back to that point in time. If they've accidentally cut something, we can very often recover most of what they have accidentally deleted. That snapshot is also taken when they navigate from question to question, and then when the exam is completed. So it gives a really nice walkthrough of their experience throughout the exam. And so then after the exam, we also continue to provide support for applicants who have difficulty with uploading their exams or any other questions they might have. Now, we don't do investigations based on an applicant's request. If that happens, we would send them back to your office and have the CalBAR team make a determination whether or not an investigation is warranted. So with that, I'm going to stop sharing for just a moment and then pull up the software and we'll walk through that very quickly.
Thank you, Cindy.
Sure.
Questions, comments from the
Yeah,
committee?
yeah, thank you. Any questions before we start
And
there?
do like a live demo as well.
Okay.
Yep.
I have a quick question.
Got it.
Cindy, you said that you do a text-only snapshot when somebody cuts 500 or more characters, which would be helpful if that was accidental and they lost it. We want to be able to put that back in and grade it. What about if somebody adds 500 or more characters within a time period that seems unrealistic?
Sure. So there is not a report, a large scale report that for every applicant, but we can look individually at both log files and what we call a character count that goes minute by minute with characters. So we can see when there has been a large addition of characters like you're referring to. So if the CalBAR team thought there was something going on, if the proctors noticed something and reported, we could go and dive into, kind of second by second, how many characters an applicant has added. So yes, that is certainly a part of what we can do. It's more on an individual basis rather than large scale, but yes.
Thank you.
And just to point out, they are not able to paste. So the clipboard is cleared when they start the exam, so they're not able to save information and then paste it in once they have started the exam. I'm going to give a shout out to Marzena for texting me that. So I'm going to go ahead and share my screen again.
Paul has a question.
Yeah, one more question.
Yeah, sure, Paul.
So how does your software interface with the remote proctoring software? Maybe you're going to get to that, but.
So I'm not planning to talk about that. What we gave in July and what we plan to give in the foreseeable future and for bar exams is an on-site exam. We do have proctoring software. It is a one camera offline, just like our exam. The proctoring is also offline. And so we did use that type of proctoring during the remote exams because of the pandemic in 2020 and then 2021 for both exams. So we don't have that in our roadmap to provide that for bar exams again. Certainly we can talk about it if that becomes an option. So I wasn't planning to demonstrate the proctoring at this point. But
Okay,
I can talk about it if you want to.
Well, that's very much on our radar.
Sure.
There's a huge amount of interest in that.
Sure.
I will self-identify as a skeptic.
Sure.
But would the functionality, if it was combined, your software was combined with proctoring software, be similar to what you're going to show us?
Yes, the exam taker experience would be slightly different if there was proctoring software enabled. They'd have to have an internet access at just the start of the exam to take their photo and have their photo upload, and then to start the exam. And then once the exam starts and is locked down, they wouldn't need internet access any longer because again, our software, both for exam taking and proctoring, is completely offline. So they would take that entire exam. It would be recorded by their device as they're taking it. And then once they submit the exam, both the answer file and the video file would upload at the same time and be available for review by after it goes through a couple of different reviews internally on our end by artificial intelligence software and then human proctor review. It would be available to your team to review.
And the exam itself would look different because as you'll see when Sydney walks us through the demo, what people have is just a place to put their answer now. Whereas if it were remote, they would need to have the question loaded in the software as well. There would be virtual scratch paper. So there would be a different applicant experience for a remote exam than you're going to see, I think, with Cindy's demo.
Yeah.
Yes. So are there any other questions before I go ahead and share my screen? Okay. Go ahead and start. And can you see my screen now? Okay. So this again is what we refer to as the dashboard. And you can see there are several sections under the My Exams. There's downloaded, and that's this demo mock exam. Here's one that is ready to download, and this is a demo, but it's a copy of the July exam. So I'll show you how quick it is to download. So you just press that button, click download exam, and it will start downloading. It's a little bit slower because I think Zoom is running, but that's how fast it is for the exam itself to download. I'm going to go ahead and show you the mock exam though, and I can show you also what the actual exam looks like, but it's a very similar experience. So again, this exam is non-secure, but if it were secure, it would shut off my internet. You wouldn't be able to see it. So you can see that the icon shows unlocked, but for actual exams, it would show as a secure exam and the padlock would be locked. You can also see when you are clicked on a particular exam, the tools that are enabled for that exam session. Here, spell check is enabled, copy and paste is enabled. We don't have a calculator turned on, and we don't have highlighting turned on. If we were giving an exam with actual questions, we could turn highlighting on, because the highlighting is only for question text, not answer text. And so there's no point when basically the question is answer question 1 here. So we don't turn it on for on-site exams, but we would for a remote exam. So I'm going to go ahead and enter the password. We'll pretend it will unencrypt the exam. So there are some exam notices that applicants see prior to their device locking down. And so basically this is for a mock exam, and it just says, you know, this will help you understand how to use our software. You click next and go to the next one. So there are no sample or practice questions in our mock exams. This is just a tutorial that is designed to walk them through how Exemplify works. And then this will let them know that their work is being backed up every minute. The snapshots are taken and available in the portal for only every 10 minutes, but we do have them on our server for every minute if we needed to go back and find those. So it's also letting them know that all of their other applications will be blocked. They can view these pre-exam notices if they choose during the exam, and then it will say, go to the continue button. And these instructions are, I think, generally announced at the beginning by the proctor. And so then they come to this screen. So this big yellow screen makes it really easy for the proctors to stand in the back of the room and see that everybody's in the same place and ready to start the exam. And so when the proctors give the go ahead, they can click continue. And again, another fail safe to make sure no one starts the exam before they're supposed to. They click here and they start the exam. So the exam will load. And it typically doesn't take quite this amount of time. I think it's probably because I'm on Zoom. But here you see the first question in this exam, this mock exam. And this is another really important tip. We have exam takers all over the country do this in every exam, is that they'll answer every question from their question book, all in the same window. And so we want to make sure to instruct them several times to navigate between questions and answer each question where it belongs. So we just talk them through navigation. There's a couple of ways to navigate. They can click here to go to the next question. And so this is a question about if they need to stop their exam and use the restroom, take a comfort break, they can hide the exam. And that way people behind them can't see what they've worked on, and all they need to do is click resume to return to that exam. So it just shows them to do that. They can also navigate by using this button down here, the next button. So this is a good feature that a lot of exam takers want to use. and would be more important in a remote exam so that they could adjust their text size. And so you just go to this toolkit and you can make the question as large as you want up to this size. And then you can move this little thing down. So that doesn't give you much room here. And for the questions in an on-site exam, it's just, you wouldn't want to do that, but it is helpful for other types of exams. So we have all of the features that for formatting, like you would use in Word. It's very similar. There's bold, underline, indent. You can also use subscripts and superscripts. You can use numbered lists. So basically you can format. I think that's particularly helpful maybe in the performance exam. There's a lot more formatting. Normally in essays, I think it's just questions and maybe bold on the headings. So we ask them to practice using those features. And I'll increase this font size a little bit. I think I got it a little small. But here's a question. Again, we like to emphasize that they should always copy and paste when moving text around, just to make sure that they get the text right where they want it before they delete it. And so this is a question to help them practice that. And we emphasize it a second time in another question. So they can recover deleted text if they immediately use undo or Control or Command Z, but sometimes they take an intervening step and are not able to do that. So we really want to focus on copy rather than cut. And then here is how they can practice using spell check, and you can misspell words. And so it will underline those words and you right click, and so it will offer you some options. And then they can also set, I think this is fairly commonly used, they can set alarms individually. Oops. They can set alarms individually. So for example, when the exam is a 3-hour exam and there are 3 essay questions, you can add an alarm for an hour so you can help time yourself during the exam. I won't set one for that long. I'll set one for just a few seconds so you can see what it looks like when it pops up. But it's silent. And then it just pops up as this orange thing, and they can dismiss it if they want. They can reset another one. They can reset, I think up to, let's see, you can reset, I think 2. So they can do that, and they can practice that. And so the last, one of the last questions relates to what to do if I have an issue during my exam. And again, we tell them do not exit because you can't re-enter, but restart. And kind of walk them through what that process would look like if they needed to do that. And then finally, we let them know how to submit the exam. And again, time will be called by the proctors. Everybody stop typing. And so then their instructions go to exam controls and click submit exam. So we have a little fail safe so that if someone does, for some reason, mid-exam, think they want to submit their exam, but they decide, oh, wait, no, I don't want to, they can go back. But to actually submit your exam, it takes clicking the submit button, this button, and this button. So you have to be pretty sure that you want to submit your exam and not accidentally submit it. So that's basically a walkthrough of the software. I'm going to go back in case anybody wants to see any of those other features, or I can exit this exam and we can look at the actual, what the actual exam looks like if you prefer, but it's pretty much the same except the questions are, you know, type your answer to question 1 here. So I'll stop for a moment and ask if anyone has questions or would like to see anything in more depth.
Mr. Kramer?
Screen reader compatibility for the blind or nearly blind. Do your software work with those?
So we do have screen reader compatibility both for Windows and Mac. I will point out though that we do not have voice to text compatibility. So while they could hear the question, answer question 1 here, they wouldn't be able to speak their answer. So we do have some accommodations that we can set for an exam, and this is typically the practice for, I believe, California and all the other jurisdictions. We will create a version of the exam for those applicants only that is non-secure. And we do that, they don't really need to be in the software until their exam is completed. And what they will do is use their speech to text software to use in Word or whatever word processing software, and they will compose their answer, and then we can transfer it in that non-secure mode into Exemplify so that the output looks like everyone else's exam. So for a remote exam, they would be able to hear the question. Unfortunately, they wouldn't be able to speak their answer into the software. At this point, we don't have that compatibility.
Because you couldn't remotely proctor that process? Is that the reason?
So the software is not compatible with voice to text. So
But it sounds like you have a workaround, but it needs to be done in the presence of supervision.
Yes, that's correct.
And do you, to prevent people from doing things like changing the clock in their local computer to fool your recording of when their last keystroke was, do you have some way to get the time from a neutral internet server or something in your software?
So the start and end time come from the device itself. So it really doesn't matter what time zone it's set in. So it will say, started at 1:01 p.m., ended at 4:02 p.m. or whatever it is. It doesn't matter the time zone. It's based on the device clock. So we have that report pulled out of our the data pulled, and then we can just see, we look at the seconds rather than actual time.
Okay, thank you.
Cindy, I have a question for you. Mr. Montgomery? Yeah, can you guys hear me? All right, cool.
Yes.
Thanks for your demo. I used ExamSoft for the New York and California bar exams in 18 and 19 respectively. And I always thought it was a user-friendly software. I'm wondering how many state bar exams you contract with, what you perceive your biggest competitors to be. And we heard a public comment today that you cost $300,000 more than the next most expensive option. So what differentiates you?
So we work right now with, I believe, including California for the July exam, 28 other jurisdictions. We also work with some international bar exams that are size-wise on par with New York and California, and also some smaller ones as well. So I will address the price issue. So we've had a long-standing agreement with California that's been renewed for many years. I believe we started working with you all in 2001 or 2. And so after you all decided to go a different route, that halved our number of exam takers by about a third. So about a third of U.S. bar exam takers are from New York, a third from California, and the other third are the rest of all of our other clients. And so it did significantly lessen the number of exam takers we needed to support for that February exam. So, we ramped down our operations accordingly. So when y'all came to us and asked us to help you with the July exam, we had to immediately ramp that back up. And since we were only doing this for one exam, it wasn't something that we were going to be sustaining. So it was a bit more expensive. So I think looking forward, should we decide to, should you decide to use us for future exams, and we can contract for a little bit longer, so we are ramping up, but will be sustaining for a little bit longer period of time. I think we can talk definitely about a more affordable solution, like we had had for many years before. So I believe the only other two vendors in bar space currently are ILG and Accredited, or Exam 4. I think that's what it's called. I can't really speak to what differentiates us from them. I'm not familiar with how their product works, although I would suspect it's very similar to how ours works. I mean, basically, you're taking an exam, you lock down the device, you submit the exam. But I can say, we offer 24/7 support. We understand California's exam takers and have worked with them over a number of years. I think, worked well with the California bar team, and we'd love to be able to continue to do that in the future. Is that helpful, or is there any other information you're looking for?
I thought it was helpful. Thank you.
Okay, great.
Cindy, this is Alex, the chair.
Hi, Alex.
One of the issues that has come up earlier today is how certain applicants sort of experienced data corruption. And I don't know if this is something you will cover, and I don't want to jump the gun if this is a topic you will cover later on, but a concern that has come up earlier this morning is how a couple of the applicants, after they exited the exam, somehow the computer crashed, or there was some form of corruption, and they couldn't retrieve the data even with the help of forensics or computer tech. And so the logical question I wanted to sort of ask you to think about is whether the software itself would have any impact on the hardware, and whether you have had any prior experience or instances like this where upon exiting the exam, the file got corrupted and the applicant wasn't able to retrieve the file.
So I'm not familiar with the particular case. We would of course, investigate any instance of that nature. One thing, we would have to have is either a look at, the device or the log files, if there is any way to get the answer uploaded. And so I'll back up just I hadn't, planned to talk about that particularly, but certainly I can. There are always, historically, there are always at any exam a handful, and it usually is just a handful. And this is a normal exam. I'm not going to talk about the remote exam because that's a different instance. But in a normal exam on site, a few applicants who, for whatever reason on exam day, their device will not load the software. Typically, we have found that has to do with their antivirus somehow blocking it. Sometimes a restart will solve that. Sometimes it's more in depth. Sometimes if updates to their device have occurred between the time they took their mock exam and exam day, there's something that makes it not compatible. So there are always a few who aren't able to start the exam. There are an even smaller number who after the exam, for whatever reason, either mid-exam or after the exam, and it's unfortunate. We hate to hear when we hear these, but something happens. And, unless there's an overall software failure that affects a number of applicants, it's really difficult for us to tell what has happened specifically. The reason is there's so many different devices with so many different configurations that it's really difficult to troubleshoot the one-offs. We will do our best for any applicant. We want them to have their answer uploaded and graded and be successful on the exam. That is our goal, and I know it's your goal. But we'll do everything we can to investigate what happened and try to extract that answer to the best that we can.
I appreciate the candidness. So one of the sort of the considerations is whether it's possible, for example, for the applicant, if given the option, is to send the computer to ExamSoft to see if there's any way, shape, or form, their file would be able to be retrieved, because you can imagine how upsetting it would be, after spending all of the months preparing for the exam, taking the exam, and upon exiting the exam, the computer crashed, couldn't retrieve the file, couldn't upload the file. It's scary. It's daunting. And I want to make sure that we are doing everything we can to,
Yes.
give applicants options, until everything is exhausted. I want to make sure that their interest is protected.
Absolutely. And I agree. I can't promise that we could that an applicant could ship a device to us and that we could forensically extract their answer. It depends on a lot of different things. Certainly whether the device can even be restarted. And, I do know of cases where the device just died and it is not possible to restart it. However, I can't promise that, but we will certainly, if any applicant is in that position, the best thing is for your team to get in touch with Marzena and me, and we will work with our support team and our engineers to get the best possible outcome that we can.
Thank you. And we're not expecting a big population, but just a couple of applicants. And so,
Yeah, it is always just a few. Like I said, across the country, out of all the exam takers, there will be one or two. And and I don't mean to minimize that it's one or two, because for that particular applicant, it's horrifying and heartbreaking. I can't even imagine how they must feel. And we do feel for them, and we will do whatever we can to try to help them.
thank you. And that's a very important value proposition as well, just being able to give them the chance to send a laptop to you for forensic analysis. That is an important consideration for us, so thank you.
Sure.
So I would ask Audrey perhaps to, if you haven't done so, just, give the applicants an additional option to explore. Questions from anyone else? Donna?
I have another question. Cindy, so a lot of applicants like to practice the functionality over and over of the testing software.
Yep.
By doing publicly available, old test questions, responding to them in the mock exam. So they are certain that they are very comfortable with the functionality, can
Sure.
move within and around the functionality. What ability would applicants have to do 2, 3, 4, 5, 6 mock exams so they can continue to practice using the functionality with real bar exam, exposed, open, public, but real bar exam questions?
Sure. Thanks, Donna. So they can take the tutorial mock exam up to 5 times. And if they needed to take it more, we can increase the number of downloads for them. Not many take it 5 times. But if the CalBAR team provides us with those old exam questions, those publicly available exam questions, we can load them in and we can create a second mock exam so they can have a couple of options. They can try to practice using real questions or, old questions that are more realistic, but also take that tutorial. And again, for a mock exam, they can take it as many times as they want. They'd need to call support if they take it more than 5. But I think you'd want to be clear with them that no one will be looking at their mock exam, realistic exam question answers or providing feedback, because that's very often a question that comes up in those instances. And I'm sure, of course, you would do that, but just to make clear, because that's a question I've heard asked of support in other cases. Like, when will I get my results?
Would they have the ability to download the answers that they have provided or to print the answers in case they wanted to share them with their bar exam tutor to have them sort of look at how well they did?
No. Exam takers don't have any ability to view their answers. I suppose since this would be a mock exam, we could create it as a non-secure exam. And they could paste those answers into like a Word so that they would, the questions or whatever. They couldn't paste the questions, only their answer. But they could do that. That would be an option. I'm just kind of spitballing here, but that would be an option that we could enable as a non-secure for that instance.
Thank you. And just for committee members, Cindy had said in her presentation that they strongly encourage everybody to take the mock exam to ensure that their computers meet the minimum system requirements. I just want to make sure that everybody here knows we require everybody to take the mock exam to ensure that their computers meet the minimum system requirements, and because it gives them the opportunity to familiarize themselves with the functionality.
Yeah, thanks, Donna. And really, since they have the option to take it more than once, we would encourage them to take it very close to the exam day, just so they know that it's still working. There haven't been any updates that interfere, and it gives them the opportunity to call support for assistance if for some reason Exemplify doesn't launch for them again.
I'm trying to remember from all the communication we sent out. I think it's a week or yeah, I think we have to have it a week before. And because of the way we can do the exam in person, we have people show up who haven't done it, and then they get a handwriting packet. So it's people who did not do the mock exam still come to the exam and are able to switch to handwriting.
I think in the past, we have considered making that a requirement, meaning unless you go through the mock exam qualification, you can't really take the bar. Well, not taking the bar, but making qualifications so that we know they have done that step.
Right, we can see it in ExamSoft's backend. We can see that they have or have not done it.
Right.
And so, for example, one of the things that we try to do to ensure that everybody is aware of the requirement that this is mandatory for them to be able to take the exam on their laptop when they show up. The committee members are all aware of the countdown emails that we send every Friday in the 6 weeks leading up to the exam. Every one of those emails talks about upcoming deadlines, and we repeat those over and over. And we also post those emails on our website. Because applicants are studying for the exam. They may be responding to emails or looking at emails. They may be looking at the website. So we want to make sure that it's available in as many places as possible, because we know that they're not all looking at the exam. There's also a statement, I believe, in the declaration that they signed before they take the exam to apply to sit for the exam, that they acknowledge that they have to take the mock exam. But we do send them reminder emails, or in those countdown emails, we're very clear about the deadline, and it is roughly a week before the exam, in order to be able to do that.
They could take it. We want them to take it before. Yeah.
I just think about myself as a bar taker. I could imagine I would want to take the mock exam as soon as possible to make sure that I felt familiar, and then I'd want to take one, maybe not a full mock exam, but just the night before, to make sure no downloads got in the way of this. So when I came the next day, I feel very confident that when I sat down the night before, it was in the morning too. Is that what are they able to do that to me? Like they could take the mock one. Let's say they were doing two, could they take one the day before?
Sandy, question
I'm
for you.
sorry. I'm sorry. Could you repeat? I mean, not all of the lead up, but the question itself. I was having a hard time hearing. Could we require them to take one the day before?
Or you mean an optional one? Yeah.
Oh, an optional one? Sure. And they can take the same exam up to 5 times, the same mock exam. But yes, I mean, it's not, we can set up multiple mock exams during during the registration period to give them the option to take take them as many times as they want. And we could set the maximum number of downloads to 10. You know, there's no hard and fast rule that it has to be 5. But I will tell you that most don't take advantage. I see 2 pretty frequently, but really not that many that are more than a
The
couple.
mock exam resides on the computer locally, meaning applicant can access it at any point in time, whether it's the day before, the week before, whenever, as soon as they're done downloading, basically.
Yes,
that
correct.
Yeah.
Yes, that's correct.
And we always advocate, and the staff does send out emails, reminders to remind people to update the software, to use the mock exam to the advantage, because a majority of the issues that we have had in the past, troubleshooting related issues, could easily be resolved had they done the mock exam. And this is the reason why we have instituted procedures in place to make sure they're constantly reminded again, but ultimately it is the applicants who ultimately decide whether to use the mock exam or not.
And it looks like we actually gave them this time till the Friday before the exam to do the mock exam. We gave them long lead time to complete the mock exam.
Yeah, and the deadlines are on our end are soft. So even if they don't complete it on that Friday, or if they've already done one on that Friday, by that Friday, they can still do one Monday evening or Sunday night or whenever they choose to do, right up until the day of the exam.
Thank you, Justice. Any additional questions or comments?
I'd like to see the demonstration.
Mr. Yokoson would like to see the demonstration. So Cindy, the floor is back to you.
Okay, so the demonstration of the software again?
Yeah.
Okay, let me take you through. I'll finish this exam, and then I'll open the other exam so you can see that. So here's what it looks like when we finish. So we'll submit this exam. So here it's preparing the answer file. It's now uploading the answer to our server. And now I have the green screen. Now that one uploaded pretty quickly. And really the files are not large when it's just the exam answer file. So it really does happen just about that quickly. And so they've got their confirmation number 1. I'm going to return to the dashboard. And we'll see confirmation number 2 and the completed date and time. And so I'll open this exam this time. And so again, this is non-secure, even though it's a bar exam, it would be secure on the day of the exam. So I enter the password to unencrypt it. And again, so this is what they would see on exam day. These are the pre-exam notices they would see. So it's telling them that your work will be backed up every minute, that this exam has 3 essay questions, that spell check is enabled, that the output will automatically be in the format that the graders want to see. And then again, we're instructing them as a last minute precaution. If you have an issue during the exam, do a hard reboot. And if you aren't able, you need to raise your hand so that you can start handwriting. So we'll now go, we're at the stop screen. The proctor said, okay, move forward and begin the exam. So it's taking a moment to just load the exam. Okay, so this is on exam day, what the examinees, the applicants would actually see. They'll have their, I don't know how their question in paper format with them. And we want them to type question 1 here. And it tells them when they have finished answering this question to select next. And so you can see they have 3 questions, question 1, question 2, question 3. So if they decide, you know what, I don't think I'm ready to answer this question 1 about family law or whatever it is, I'm going to move to question 2. They can flag question 1 puts a flag that I need to go back to that one. So it's more helpful if you have a long row of multiple choice, because you can then filter by your flagged questions. For essays that there's only 3, it's pretty straightforward to know if you've answered the question or not. But we'll go on to question 2. They've typed their answer to question 2. So you can see if you have any typing in the answer field, this turns blue to indicate that there is some form of answer there. Now, that doesn't mean they fully answered the question, of course, but it just does mean that they have done something in that text box to answer the question. And so then we've moved to question 3. You can see that it doesn't say go to the next question, but then they can submit the exam from there. But I'm going to stop right there and ask if anyone would like to see any other features or any other part of the software while I still have it open.
I used ExamSoft so many years ago, and I can tell by and large a lot of features are roughly the same. I mean,
yeah,
like when you first start, the hand button color red, it's trigger memory.
I'm sorry.
No, it's good memory.
Oh, good.
No, I mean, in some way I find it comforting because, features are we want features to maintain, to be consistent, across the board over the years. We don't want, new features. So this is good. I mean, I'm familiar with the software and it looks like it's still roughly the same.
Right. And I'm going to accept out the remote exams of 2020 and 2021. The software has remained essentially the same. And we do use for bar exams, our most tested version number for bar exams. So before we'll use a version of Exemplify for bar exams, we'll have to have millions of uploads on it at this point. And so we will have known what any issues are and be able to work those out. So ever since the July 2021 exam, we have had very few issues. Now, that exam had some other complicating factors, because of the monitoring and the remote exam. But as far as on-site exams using this software, we've had very few issues. Like we talked about earlier, it's just kind of those one-off edge cases that we're seeing.
Questions, comments? Mr. Kramer.
So you're describing the mock exams as unsecured. And is that the format that our people would be testing their equipment in?
No. So the mock exam that applicants see would be secured. And we do that purposefully so that the tutorial, for sure, we always want to be secured. And that is so their device can go through that lockdown process. And so that they can see, oh yeah, I see that I'm going to have to disable my antivirus to get this to work. And that's one of the recommendations in our minimum system requirements is that you temporarily disable your antivirus if it interferes with the software. So we want them to be able to test their device as more realistically as the most realistically that they can, as they will on exam day. Now, we were talking about creating a second optional mock exam that might be non-secure with past questions and making it non-secure so they could extract their answers before they submit it. Once an applicant submits their answers, the only people who can see it are your team. So we don't want applicants to be able to go back and see their answers on a bar exam. It's not designed to do that. So that was the instance we were talking about for a non-secure. Here they're non-secure because if I created secure exams to show you, you wouldn't be able to see them because it would cut Zoom off, it would cut my internet off, it would cut everything off except Exemplify. So that's why I have to create anything I demo in a non-secure environment.
Yeah, and I could see that seeing what you wrote later could be triggering as well. Thank you.
Could you show us an actual question and how it looks to the applicant and how they go about answering it?
Sure.
I took the exam by the old school writing.
Sure. So Yeah, so I don't have the actual paper questions. We don't ever see those. We don't know what the questions to the exam
Okay.
will
So
be.
where is the question
It's
and
in your,
where's the
it's
answer?
in your hand, right? Because they only do the window. When we did the remote exam, the questions have to be
Okay.
in the software.
So the applicant gets the
Paper
questions on
questions.
paper.
That's right. And they basically just write in this,
Got
like
it.
a word.
Okay. And then,
esque
and the second question, how does it come back to us then for grading? I remember a few years ago, the applicants would upload it that evening and staff would actually print out answers for the graders. How does it work now?
So I don't know if they're still being printed, but we do have an application for the administrators. It's called PrintX, and it will allow them to either print or export into a PDF format for distribution to graders. And it formats those. I don't know how you format them, but most jurisdictions have like a cover sheet and non-identifiers that also like codes, seat numbers, so that you don't know who the applicants are, but you can put them back with the correct applicant. I'll let Audrey.
We export everything from their back end in those anonymized ways with anonymous numbers that come to, and then our graders can go basically into a database to get their,
And then they split it up.
their
So-
PDFs.
So no more boxes with,
Well, we have the handwriters, right? So we have to
Yeah.
scan those. So we have to deal with a lot of boxes, but
That's why remote is always a good option, because the paper is what takes the most time.
absolutely, and of course the security too. Over the years, we've had examples of cars getting stolen with a box of exams.
anytime you
in the
have
trunk,
things going back and
things like
forth in
that.
boxes,
It has to
there's
happen.
human error.
It has happened. So, Thank
Audrey,
you.
what was the year in which we used ExamSoft for the first time? Do you remember the year it was?
I think it was 2002.
I'm gonna say.
Or 3.
I'm gonna say it was about 2003.
Three.
It was my second year on the committee, and it was considered highly
Revolutionary. Yeah.
avant-garde, whatever.
Yeah. Additional questions and comments? Let's see none. Cindy, do you have any more to your presentation?
No, I don't, but I did want to thank you all. You had great questions. And if you have any other questions you want answers to, or any other comments, maybe you can share those with Audrey. I'm happy to help out in any way I can, but we just really appreciate the opportunity to talk with you today.
Thank you, Cindy. Your presentation has been very informative, and we thank you for your participation today.
Okay, thank you. Well, I'm going to go ahead and stop sharing my screen.
Thank you,
And
Marzana, too.
yes, thank you, Marzana. Helpful in the background as always.
Thank you all.
All right, thanks.
Any other questions regarding agenda item 4.8? I understand it is 12:10. Let's go through a few more agenda items before we go break for lunch. Sounds good. My understanding with respect to agenda item 4.6 is that it has been withdrawn. So, okay, right. So we'll go back to 4.5, which is the action on 2025 minimum cumulative 5-year bar exam pass rate compliance reporting for accredited law schools. Mr. Leonard, I believe you have a presentation for us.
Thank you. Thank you, Alex. Okay, so we are here to talk about the 2025 NPR reporting for California accredited law schools. This is a regulatory figure with a very specific calculation in the accredited law school rules, and all of the accredited law schools are required to report a 40% minimum NPR each year. So this is a 5-year cumulative number based on only those graduates who took the bar exam during that 5-year period. That's why there's a little bit of a lag. The most recent exam is largely the July 2024 exam, but in certain circumstances, February 2025 results are also included for those graduates that wouldn't have more than 10 opportunities to take the exam since graduating. The good news is that for the second year in a row, all of the law schools have fully met that target, and the vast majority of the law schools have increased their NPR versus last year. One question that you might have is the impact of the February 2025 exam and any particular remedies on this. And while most schools did experience a much higher February 2025 pass rate than February 2024, we actually believe that had the rates held similar, they still would have been in a compliant posture. In the past, the committee has asked staff to work in particular with schools that have a 45% or below pass rate to help prevent issues. And we're happy to say that this year, there is no school that is in that posture. All of the NPR values are at least 50% or above. So we're very glad to share that. We attached a chart that shows the individual NPRs for each school. That chart is placed on the State Bar's website and throughout the year. We invite prospective and current students to take a look at that chart when they're determining which school might be the best school for them when they're selecting their legal education. Are there any questions? Okay, Paul, would you be interested in calling for the motion to accept the report?
Is there a resolution to post? Or? Yeah.
Can we put it up?
I'll make the motion. I'll make the motion.
No, although I think it is very important to note that when you look at 2025, the NPR rate is much better than prior years. It's all because of the relief we've granted applicants. I want to thank each of our community members. You know, we have done all we could, and now we're seeing the fruits of our effort, you know, in terms of helping schools bring up their NPR rates, but also making sure that all the applicants are afforded their appropriate relief. And so this is really the direct result of this committee's efforts. With that, Devin, please take roll.
Bolton?
Yes.
Cow, not present. Gongora?
Yes.
Kaplan?
Yes.
Lawrence, not present. Oh, Kramer, excuse me.
Yes.
Lawrence, not present. Lynn, not present. Maciwala?
Yes.
Montgomery?
Yes.
Peak?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Reyna?
Yes.
Reyes?
Yes.
Jokelson?
Yes.
Chan?
Double yes.
With 13 yeses and 0 nos, the motion passes.
Thank you, Devin. As indicated, agenda item 4.6 has been withdrawn, so we're now on agenda item 4.7, which is an action on the inspection report of California School of Law. Ms. Leonard.
Thank you. And I believe that Dean Hunt will be making a public comment after the initial staff presentation. So I would ask Devin to scan the audience for Dean Hunt so that he can join us after I make my initial remarks. Paul, do you have any remarks you would like to make before I begin?
No, go ahead.
Okay, thank you. Oh, sure. How about that? Better? Okay, great. Okay, so California School of Law was inspected last summer. Previously, the committee in 2022 noticed a number of issues related to fundamentals and compliance with the guidelines and renewed the law school's registration, but asked that the renewal period be 2 years rather than the typical 5, but afforded the law school full authority to determine how it will tackle those issues. The law school made one very significant change. They had significant IT issues. They replaced their materials. They enhanced their IT support, and they've had a very stable presentation since then. And that's extremely important because this is a distance law school, and the majority of their classwork is asynchronous. And I'm sorry, it is synchronous, it is live. And they do have all of their student services that are also via their technologies. So that was a very important improvement. With respect to the other issues, there was a lot of challenge. And so when the team returned this time in August of 2024, there were fundamental issues that may be contributing to the school's limited performance and limited ability to license students. To license graduates who ultimately take the bar exam. So if we look at the pieces of the chain, if we look at the communication, we see from the very beginning on the website, though just a few students from each class ultimately go on to take the bar exam, the school discusses an 83% pass rate for first-time takers during a specified set of 3 bar exams, not discussing repeaters, including periods in which the repeaters had a 0% pass rate. This law school has a significant withdrawal rate immediately after starting within the refund period. And then it also has several elements that could be quite excellent, but as used currently, do not appear to be supporting the students. So specifically, they take a 4-week pre-course that is significantly easier, according to the dean, than it will be later when they enter the program. So this school chooses to have an absolutely compliant admissions policy, admitting all those who meet the minimum qualifications, but at the same time has limited academic support, may overstate the possible outcomes through the website, and may not give a realistic experience as to what it's going to be like based on the 4-week pre-course that happens. In addition, they're asked to go from a 2.0 experience at an undergraduate level to a 2.0 experience at the graduate level within 1 trimester, and a 2.5 graduate level by the end, and to pass a capstone course. So at each of those 3 points, they lose additional students. There is further loss between 2 and 3, but good retention between years 3 and 4. The report talks about specific changes that the law school could make. They generally are very modest in cost. They should be very achievable for the school, and it's believed that it will have a significant impact on the outcome. Two possibilities are suggested for motions. The first one is to renew and to again give the school the opportunity to make the changes as they see fit, moving from a 3-year period that they had previously to a 2-year period now. Another possibility is to recognize that the law school has already been afforded an opportunity over these past 3 years to make those changes and has not yet done so. In that case, a warning letter may be more appropriate, so you can see an immediate plan, and if necessary, provide the supportive guardrails of a probation situation if you think that's appropriate after reading the warning letter. That's what I plan to share as an overview. And at this time, are there any comments from Paul before we turn to Dean Hunt?
Yeah, and in my mind, the key issue here is we talked about it in the performance report. What is fair for students? This school is among the least expensive of the law schools, I believe.
Yes.
But it is not free. And so You know, we talk about protecting the public here. We talk about protecting law students, protecting the public from incompetent lawyers. But the countervailing notion is that do we want to unnecessarily stifle the dreams that some have to become lawyers? There's a definite tension there between letting somebody gamble, if you will, their tuition, their time, lost time with family, against a possibility that's not all that significant that they're going to make it through to the end and become a member of the California Bar. Where do we draw that line? And this is a school where, as Natalie mentioned, so many people don't make it to their JD degree, much less to passing the bar. I welcome the future opportunity for us to speak more generally about where we want to draw that line. Here, though, we have a school where we've identified the issue and we need to do something with it. So I just wanted to set that up. The dean is going to get his chance to respond, I guess, next, and then we'll wrestle with that question and others. So, Natalie?
Sure, thank you. And just to let you know, this school was founded in 2007. The dean is the founder, the dean is the owner. He is definitely committed to the school, and he'll talk to you a little bit more about his plans. And just to give you an idea of a couple of numbers, all of these schools put forth a disclosure, which is a format that they all use in the exact same manner. And if we look at a couple of examples, for those first-year students who started in 2021, there were 52. Currently, there are 8 remaining. For those who started in 2022, there are 3 Ls at this point. There are 2 remaining from that initial number. So those are examples. There may be other schools with similar situations, and the State Bar staff works with all schools in a similar way. Here, there are clear levers that the school can pull that can improve the performance, and that's part of what the inspection report talks about, just improving the fundamentals to improve the outcomes. At this point, I'd like to welcome Dean Hunt and anyone else he so chooses for 5 minutes of public comment.
Can you hear me okay?
Yep, we can hear you fine.
Great. Thank you for your time here today. I would just like to say that, you know, while the inspection was done last summer, we have spent the last 14 months really working diligently with Natalie's guidance and help to comply with the issues that are raised. I understand from that was the performance report 4.4 that Natalie gave earlier, that obviously attrition is a serious concern for the State Bar with the students, and we are going to take it seriously as well. We've implemented a number of changes that we believe have already started to pay off and will reduce the attrition here significantly. While our numbers for the bar results are small, it's not a lot of students. Over the last 5 years, 81% of our students have passed the bar. So we've been extremely successful in identifying people who are capable. Without a doubt, though, the attrition factor is there, and we will do everything we can in the future to be sure to comply with whatever regulations the Committee of Bar Examiners comes up with. If there's any questions, I'd be happy to take them, but otherwise, I understand the situation, and we will work diligently to correct everything that we can.
Yeah, can I ask a question of Dean Hunt? Yeah, you have a very good pass rate for those few students who make it to the end and obtain a JD degree. But those few are what, maybe 85, or rather 15% of the initial enrollees in your school. Is that a close number?
As far as sitting for the bar exam, yes, I would say about half of our students sit for the bar exam, half do not. So from what we initially enroll for first year, about 15% will go on to sit for the bar exam. The other 15% that graduate from the program do not. So our attrition is somewhere around 70%.
Okay. I think, as I said, we're, at least in my memory, we haven't really adopted a formal position about what's a level of attrition that doesn't concern us. But let's say even if we didn't set a level, or we said 90% was okay, for instance, that would be at one extreme, I would say, guess. We would still want the people who are considering coming to your school to know that they had maybe a 10% of chance of, on average, of coming out with a JD degree. And Natalie, I believe the inspection has told us that the disclosure of that kind of information to potential applicants is deficient in our eyes. Is that correct?
It's been a challenge on two fronts. The first front has been addressed. The disclosure document is placed more prominently and has been corrected. It did take several cycles to do that, but that has happened. There continue to be just discrepancies in discussing the attrition in general. So for example, looking at the 2021 class 52, down to a current class of 8, which includes 2 visitors, so it's actually a class of 6. The numbers that we calculate for attrition are significantly higher, but because there is not a specific attrition target, there's no recommendation about any type of attrition target in the report. It's really the fundamentals: be clear in the communication, and then provide the support needed for those that are accepted.
So is the current disclosure adequate in your opinion?
The specific disclosure is now appropriate, but at the same time, looking from the beginning of the homepage, the program begins with a splash on the front page that says 83% pass rate, no LSAT, $350 a month. And so it gives, it doesn't give a full picture of what it is like to attend the school. The school has been willing to make a few changes to link the price to the payment plan so they understand how long they'll be doing that, and how many students they're talking about for that pass rate, but it doesn't give the full picture. So the disclosure, yes, the website communications, not yet.
But the website is how people effectively is the means of disclosing these days, isn't it?
It may be, yes.
Okay.
So let me try to understand the total program, meaning all 4 years tuition was $36,000, is that right?
Yes, and then $1,800 in fees. It is one of the most modest cost programs that's in operation.
But I do have some comments and statements before we start. I want to make sure we have all the questions answered and addressed by Mr. Hunt. Mr. Reyes.
Yes, Dean Hunt, thank you for your comments today. I just had a question. Since the attrition rate is as high as it is, what sort of academic support do you provide for students at any time during their enrollment?
All of our incoming students take a 1-month free introductory course where they really learn law school fundamentals, briefing cases, using the IRAC writing formula, how to outline a law school course. So we try and set them up for success with that intro course. We are now using that intro course as well as a method to try and weed out students that shouldn't move into the program. And then throughout the 4 years, we have a dean of students who provides academic support. He does tutorials outside of class time, meets with students and suggests resources and study aids like Callie and Quimby, and things along those lines.
Dean, do you happen to know of those who have dropped if they have enrolled in other law schools, or that's just not something that you track?
Well, students who leave the program, if they are going to another law school, would request a transcript. I would say the students that leave the program, we don't have any college kids. It is all working adults. And so the students that leave the program either leave for personal reasons, or academic reasons, or a combination of the two. We don't have any students having academic success moving to other programs, that's for sure. But some students drop out and they'll surface a few years later and request transcripts to go to another program. That does happen.
Okay, thank you. My last question is, I was able to look at the website for your school, and I did see that the tuition is $350 a month. I'm just not familiar with the process. What happens if somebody drops that first year? Are they entitled to have to expend the entire amount of tuition?
No, we run on trimesters. So we run on 3 semesters a year. It's a traditional 15-week, 3-month semester. We charge $3,000 a semester. So they're only charged by the semester. If they drop out at any point before halfway through the semester, their tuition is prorated for that semester. So we're not charging by the year. If you get past the halfway point of the trimester, then you're charged for the semester. The truth is, any of the students that drop out, I would say almost all leave with tuition balances, and really we do nothing to try and recover that money. So for the students that are dropping out, we don't recover another dime from them as far as tuition owed. Most students that fail out or drop out leave with substantial tuition balances that we never recover.
Thank you, Dean. I appreciate
Thank
it.
you, Mr. Ray. Dean, I got a question for you. What are your admissions requirements in the context of the LSAT scores and GPA?
We do not require the LSAT. About half of our students have taken it, about half have not. And we have noticed, as far as the students who moved through the program during the first year and passed the baby bar, we have about a 50-50 success rate. Half of our students that are graduating have never taken the LSAT, the other half have. As far as admissions, we really try to be a law school of opportunity to give students a chance to attend. So we have students who have, bachelor's degrees from UCLA, Berkeley, Harvard, and we have students who have attended business colleges with an associate's degree. Every now and then, I'm not sure how much you're familiar with the CLEP test, but there is a back door where you take the CLEP test to be admitted to the program. And I'd say we probably get 1 or 2 of those per year at the most. But interestingly, they're a very successful group. The students that can pass the CLEP end up doing very well in the program.
I appreciate the the phrase, you providing them with a opportunity to become a lawyer. But I think at the same time, my concern then is if LSAT scores are not required, then potentially you may be admitting students who are not qualified to begin with, right? Perhaps the attrition could be attributed to the lack of academic performance, right? And if that is in fact the case, then I don't think it's it's far stretched to say that they are doomed to begin with. Again, I'm not suggesting that, all the students are not qualified, but there's got to be some standard in place to weed out, students who are actually not qualified. Don't you agree with
And
that?
I do.
Prior
I do
to,
agree with that. There are, we have tightened the screws. Our admissions committee is looking at students' transcripts and students with extremely low GPAs. We have started to exclude from the program in light of Natalie's advice from when the inspection occurred. And but there is another side to it as well, which is all of our students are working adults. Some of them, in fact, most of them have not been in college for somewhere between 10 to 20 years. And so their academic performance from when they were 18 through 22, and now I'm talking to a 40-year-old who'd like to go to law school, isn't always the greatest indicator of their ability to succeed in law school. We have had students with very weak undergrad do well in our program and pass the bar. But I do understand your point, and it's a good one, and we are trying to tighten it up because we understand it's a point of emphasis here for the state bar.
So some context may be helpful here, just so everyone is on the same page. Unaccredited law schools are not required to use the LSAT. There is a guideline that encourages the use of that, but it is not required. For this particular school, because in the 2021 inspection, they were not able to articulate a standard that would help them to indicate why they admit people, this committee did recommend that the school begin using it. When we arrived for the inspection at this time, we learned that the school did not, but to provide context, I do not believe there is a single unaccredited law school that does. And at that time, the dean raised concern about being the sole school to require it for 100% of students.
Thank you. Any questions for Dean Hunt? Seeing none, thank you for your time, Dean Hunt. We really appreciate you joining us today. We'll now discuss what we're going to do among the committee members, and we'll get back to you.
Thank you very much. I appreciate your time and your questions. If you do have any other questions, obviously you can get them to me through Natalie. I'd be happy to answer them.
Thank you. So my take is, I'm looking through the file, and I do see evidence of good faith efforts. That's always been my sort of how I live and practice as a lawyer. I want to see good faith efforts, and if they have corrected 14 out of 29 violations, that's not trivial. I mean, things like information systems, testing accommodation, better disclosure requirement. I mean, that stuff required planning and investment and implementation. So, that's not trivial. And sounds like, Ms. Leonard, you have already confirmed that at least some improvements were actually verified and not just promised. So that's encouraging. But also, they also tried new ideas. The Intro to Law course? Is that right? I think he sort of touched on that. Even if it isn't effective, but I think the attempt suggests they're looking for solutions and not just, coasting. Obviously, bar exam outcomes and year-to-year advancement, it's sometimes it's beyond their control, but it did improve. Am I right? A little bit, somewhat.
Yes.
Okay. So that also the changes, then in that case they're not just cosmetic changes. They do have some relation to improvement, but the concerns remain. The attrition numbers, and Mr. Reyes, you sort of touched on that. They are catastrophic. I mean, 85%, 95%, 67%, even with some increase in the bar passage. I feel like, losing that many students, it tells me that their admissions are either miscalibrated or the support is not it's just not adequate, or both. And then there's some transparency problems. They were flagged in 2016, 21, and 24. And then, when the same issue arises again, across three inspections cycles total. I mean, it suggests some structural resistance. It's not like an oversight. And if I'm looking at the numbers now, the numbers are pretty bleak. We have 45 admitted students each year, and multiply that by 5, you get 225 students, but only, am I right, only 11 licensed attorneys came out of that cohort, the entire cohort? So 11 out of 225, that's like 5% becoming licensed, which is way below other, other unaccredited law schools. So, but again, striking a balance, making sure we all have all the facts. It doesn't feel like we're dealing with a purely predatory school. And I've always been against predatory schools from day one. And Ms. Leonard, you know better than I do, I'm always against that idea. And we have shut down schools with that type of behavior. But I'm not feeling like this is what we're dealing with here. They're not just sitting on tuition revenue, but I feel like Dean Hunt is really doing something in good faith to try to show that, they're trying to come up with solutions. That is not to say we agree with his solutions, but something to think about is whether we need to give the school a little more time and opportunity to demonstrate, results. But again, I just wanted to open up the floor for your consideration. I mean, there are a lot of different perspectives to this. I will start with Justice Mesiwala.
Natalie, I read in the report that students were talked to about the flavor of what the students reported. I know the report also says that in some of the classes there was student participation, but it was dominated by a few students, which often.
Sorry, Justice Mesiwala, we can't hear you. Sorry.
Does that help? Great. I wasn't pressing the button. Thank you very much, Judge. So I'll ask Natalie again. Natalie, in the report, it talks about your asking students about their experience at the school. I noticed that there was a section in there that talked about student engagement in classes and said that some students participate robustly, others not at all. I think we could probably say that about a lot of law schools. What do you think from your conversations with students, what is their experience like, and how do they feel about the attrition rate and the pass rate, both of, if you look at the entire student body, including the people who didn't go on to take the bar and who dropped out, and if you just look at the very few people who passed?
Well, to be honest, we actually are making a change to the way that we talk with students after our experience at the school. They did something perfectly fine, which is to bring together upperclassmen. So they had gone past the point of the general dismissal area. They generally were happy, they generally were optimistic, and they were likely in that pool where if a student reaches the 4th year at this school and they decide to take the bar exam, they have a reasonable opportunity. Going forward, we'll be asking to talk to more students at more grades, and when there is significant attrition, reaching out to those students who left, because hearing from those students is an important part of the conversation that previously hadn't been part of the process.
Thank you, Natalie.
You're welcome.
The unaccredited school has always been, this is an experiment unique to California. It's an opportunity for all persons who have the desire.
Sorry, Alan, we can't hear you.
There you go. Yeah. My mic is too close to Chan, and therefore I'm overshadowed. My take on the whole concept of the unaccredited schools is something that's almost unique to California. It's an experiment to give everybody the opportunity, if they have any thought of joining the legal profession. And it's something that we should applaud. And our effort here is to avoid the predatory school practices that Alex talked about a moment ago. For me, it's a question of caveat emptor. If there is adequate notice to all prospective students that they may very well not qualify, really be qualified to become lawyers, that's a decision for them to make. It's not up to us to make that decision, but they have to be given appropriate notice. And the way that to do that is the statistics have to be out there right up front. Vince Reyes a moment ago quoted from the website that had a pretty splashy appeal, 85% passing the bar exam. We know that's not true, but it sounds like there have been changes made to that. And I think that as far as the issue of attrition is concerned, going forward, the emphasis should be on full disclosure. And as long as the school is making those efforts, good faith efforts, I would support giving them additional time. And then I suppose there are some other issues they need to address as well. But Natalie, how are they doing as far as the exposure or the disclosure issue?
The actual disclosure is now certainly correct. The general communication, we've gone through many cycles. They are they're not very open to giving a full picture. We could even bring up the homepage now and you could see the number that they post is in fact mathematically correct. It is a small cut. It's a first time taker pass rate over a specific series of, I believe, 3 bar exams. It shows the number of people. I think it's 13 out of 16. But we've asked them to put a broader context, and to date, they have refused. We could use the support in just improving the clear communication. But with that said, the school has invested significantly in information systems. There were significant problems with the catalog. It took a lot of time to go through it, but the school did respond, did carefully review the issues, did learn from the things that were found, and did make changes in those areas.
Well, I think that going forward, certainly this is something that they need to work on, and we should continue as a function of our oversight to concentrate that on. And also, let me ask staff, when students first register as law students in California, that includes all law students, correct?
Correct.
For all the 3 levels of schools. I wonder if, just putting this out there, that we should have something on our website or as a part of the registration process, disclosing to students who are registering at unregistered schools, certainly, that it's essentially a caveat emptor situation. Emphasizing that they need to look at all the disclosures, and that entry into a law school is certainly not a guarantee of a pathway to a license, and it's not even a guarantee that they will be able to take the California bar exam down the line. So just something to think about.
Mr. Reyes.
I wonder if
Mr. Reyes first.
Go ahead.
And then Mr. Gongora, followed by Mr. Kramer.
Okay, my criticisms are not really directed at Dean Hunt's sincerity and commitment to correct things. But I look at it from the perspective of public protection and how that helps shape your decision-making. So given that a lot of the students there are working adults, this is a big decision for people at that level, family, profession, whatever. And then they're going to invest time and effort into a school. And if they're drawn to a statistic that, hey, this school has a really high percentage of passage rate, yeah, I think this is a good deal. And it's only $350 a month. So I think unless the as advertised is corrected, I think that it does influence a lot of people who may not be able to make it. Now, ultimately, it is their choice to do it. They should do their own investigation. But the more information you have, I think you can do it better. So I'm kind of, you said, Alan, that maybe we give them more time. And so my question to you, Natalie, is how much time is that if we extend their ability to finish correcting the rest of those issues, and if any more new issues came up? But if we went the other way, which was to give them a warning letter, which I'm not against, by the way, But what consequences would that have on the school's reputation or ability to function if they have a warning letter on top of it?
Yeah, well, two possibilities. If your concern is primarily around the communications, that's something that they can address quickly. I can tell you that through several rounds of communication, they have not been willing, but with an order from this committee, I believe they would be. That's something they can handle very quickly. So if you choose the extension of time option, the motion is already written such that they can provide a progress report with their November annual report, and that can be brought back to the committee in December or January for review. And then if that is satisfactory to the committee, then the school can continue on. If a warning letter is issued, then you will get a status of all of the recommendations, the plans that are tied to all of the recommendations. You will see for sure whether they have implemented specific plans, but they will also need to disclose that warning letter in their disclosures, and I would think they would naturally have a concern that that would affect their ability to recruit.
Well, the issue for me is just around this thing of correcting the attrition numbers and how they present the passage rate. You said that they have not wanted to do this. Was that a lag in the technical aspect of getting it together, or they just don't want to? Or
They have a different point of view about what a fair context to the public would be. And so what you see now is somewhat of an improvement over what was there, but I want to say we went through 4 to 5 cycles of adjusting the website to get where we are now. A link to the payment plan, and that the payment plan is more than just $350 in total. It continues till the balance is full. And though Dean Hunt does not put balances in collection, he does retain the right to do so. And then with the bar exam, we asked him to put full context numbers rather than just first timers, especially because there are multiple exams where the repeater pass rate is 0. That's information that the public needs to have. I can't recall an opportunity in which I needed to go through so many rounds and we were so far apart at that time. But with that said, it is a change that could probably be accomplished within 24 hours if the school was willing. And choosing to give the school more time with a clear directive could give them an opportunity to take decisive action to promote transparency without anything that may flow from a warning letter.
so just process-wise, what's the consequence if in 3 months, 5 months, that is not corrected on the website?
At that point,
So that, it just extends the time for correction longer than we would like to see it.
potentially, yes. You would retain the right to be able to issue a warning letter at that point if it wasn't addressed.
We do have a lot more ammos under the rules if the school does not comply with our instruction. Mr. Gongora, my brother in arms.
Thank you, Mr. Chair. Thank you all for the very spirited discussion. And Natalie, thank you for your updates, and to the Dean. One of the things I reviewed on the disclosure, Natalie, I don't know if we discussed this, was the disclosure doesn't have the 2024 July update. Do you have that number for the bar exam pass rate?
The 2024 pass rate or 2025?
Well, on the bottom of the form, Professions Code Section 6061.7A, it mentions February 23rd, July 23rd, February 2024, and not July 2024. Is that because of the timeline, or just as?
Yeah, I apologize. I don't have that handy. This is the current one. They'll issue the updated pass rates when they provide their disclosure in November.
Okay, so that's usually like a lull that we usually see, or?
Right.
Do you have that number handy by any chance? I only ask because I see a decline. So I'm trying to see if there's a trend.
I would have to check the report. I think we added the February 2025 pass rate, but I don't have it handy. I could take a look.
This one's, on this form, it shows 0 for July 2024. Is that accurate, or is that just not updated?
I believe that that is accurate.
Okay.
For July 2024, yes.
Oh, okay. I thought it was missing, but no, so it's a 0%. passage rate for that?
Yes, I apologize. I thought you were asking February 2025.
Oh, I apologize. Should have been more clear. And so with that being said, Mr. Chair, and obviously I appreciate Vince's comments, we should definitely pressure them to be a little bit better with disclosure. If I go to this webpage, I have a different point of view of this institution as opposed to what the background is actually showing me. And so I think it's important that we take some action. I could see they're trying to meet us halfway, but I think we gotta definitely set the bar a little bit higher when it comes to these elements.
Thank you. Mr. Kramer?
Do you want me to share the home screen?
I don't think it's necessary, but
Okay.
I do get that Dean has policy on, and I'm sure he's taking note about what we want.
Yeah. Okay, well, I would just offer that. A couple points to the points that were made earlier. I think we could always tweak our disclosure language, mandatory language, and require more specificity, and that should apply across the board to all the schools. To Alan's point, making sure that their students are informed when they register with the bar as law students, that's a little late in the process because they've probably already started their classes. And in fact, we still, quite often when we're talking to the law deans at CS bars, we're reminding them to make sure their students get registered with us because they have a habit of not doing that. So that would be too late. I agree with Kareem. I think we need to hold their feet to the fire. What we could do, I believe, Natalie, is we could issue a letter of warning, but we could extend the deadline for them getting back to us with proof of compliance if that's necessary. So it doesn't have to be it could be, I think under our rules, as little as 15 days, which seems rather short in almost any case. But here we could make it a matter of 3 or 4 months, or if necessary. But what that does is it starts the compliance process. So if they are not going to be able to satisfy us as to their behaviors, then we are further down the road to taking formal action, whether it's to put them on probation and then and then see what happens there. So otherwise, we have to have another meeting to find out that they haven't done what we've asked, and then issue a letter of warning. That's the first step in the process, which I hope to change and make more streamlined when we do get to our revision of those regulations.
Thank you, Mr. Kramer. Any other comments? Yes.
And I do want to be sympathetic to the adult learner, the kind of the profile of the student that enters this program. I'm an adult learner. I've been through an adult learning experience, and so I know those adjustments, those life situations do adjust. However, I think with the noticing and the updates, they might be able to have a better upfront conversation about, is this program really for them, because of the level of rigor and engagement that's needed to pursue this kind of education. So I did want to say that because I do understand that impacts attrition, and that's fair. But I just think some of the elements that are being projected are just not very informative to the level of someone entering a new program such as this. And if you have a gap in 10 to 15 years in your education experience, it's profoundly different. And so I've done that, and it's happened to me. So it's very fair, but I think we do need to pursue a path that Mr. Kramer was suggesting.
Thank you, Mr. McQuarrie. I think my final remark on this issue would be, and I would echo what Mr. Yokoson said, this is an accredited school. That means our responsibility is not to guarantee outcome, but really to ensure prospective students are not misled. And the inspection record sort of makes clear that repeated failures in forward communications remain obviously the most pressing issue. And I'm sincerely hoping, Dean Hunt, you're listening. Those must be corrected. And students deserve accurate information about tuition, about the program structure, attrition, and career prospects. If If applicants are fully informed, then the decision to enroll is full, it's really theirs. I like this phrase, honesty is the best policy, and transparency builds trust. And so, I want to remind you that those two things are really important to the committee. With that, do we have a resolution for today, Ms. Leonard?
Yes, we have two possibilities.
Okay, let's put it up and we can discuss which one to vote on first.
And so before I begin, I just want to be clear that the statements that are on California School of Law's website are in fact accurate. It's just that they do not provide full context, and therefore the public may be misled. There are two options. Under option A, the committee would renew the school's registration, schedule a new inspection for spring 2027. This allows them a year to get ready, to show that the things that we did together in concert, they can continue to carry on their own. They would provide to you a progress report in November with specific focus on ensuring that the website is clear and provides full context. And they would go forward from there. Under option B, they would be issued a warning letter, and I suggested a period of 120 days because that is the period that was most recently offered to a prior school. They would, at the end of that 120-day period, need to provide a response as to each recommendation in the inspection report, explaining how it is satisfied or explaining why it could not be or would not be satisfied and what the school's plan is going forward. That is the first step of the committee determining whether or not probation is required.
Can we scroll up to see option 2? So 120 days is 4 months. So assuming it goes out next
120
week,
days is a little too
that's
long.
into
4 months.
January.
I don't think it needs 120 days to affect disclosures. I prefer to see something shorter than 120 days, personal opinion. Opinions from others?
I agree. Can we shorten that time frame like in half or something?
There's no motion in place, so we can adopt our own, we can amend it the way we want to.
Natalie, would half of that time frame be reasonable, do you think?
You have discretion to set the time frame that you want. In the case of the other school, one of the two longtime co-owners had passed away and had become ill suddenly, and so I think there was a certain amount of leeway in the time to respect that unfortunate event.
Our next meeting is October 10th. Is that correct?
So that's about 60 days.
Is that too soon, or is that an appropriate time for this issue?
Well, I think you still have the flexibility because if you choose the renewal option, your progress report will come November 15th. And so that's approximately the same time period that gives the school one opportunity to act without having a warning letter in its file and on the disclosures. Choosing the warning letter option, it would come around the same time. It might be more comprehensive to have the warning letter, but the school can and should provide a comprehensive progress report.
So why don't we go ahead?
I think the most obvious thing is the website and what it's projecting, but there were other items as well.
Yes.
So if it's a short time period, they may, to be fair to the school, they may not be able to get to the remainder of the issues.
There is some value in giving a period of time where you've given them a sufficient opportunity to act or show that they cannot or will not, if it's just a little bit more time.
I mean, there are a lot of deficiencies, but, can we, alternative would be to set two different deadlines. One would be to set a deadline to correct the disclosure issue, and then another deadline to address all the deficiencies enumerated in the inspection report. We can absolutely do that. We don't need to have a single deadline for everything. So perhaps let me make that suggestion. 60 days from the date of the warning letter to correct any disclosure-related issues, followed by 120 days, I'm sorry, I'm speaking beyond my means, or whatever days the committee will decide on addressing the remaining deficiencies. Any suggestion as far as how many days that should be? Do 90, 120, or even beyond?
Well, it seems like if you're giving 60 days for the first one, just the remainder of time, if we want to stick with the 120, then it's another 60 days after that.
Then let's do 120 days. I do want to give Dean time to address the remaining 15 different deficiencies. Let's do that, 120 days to address the remaining deficiencies, and sticking with 60 days for the disclosure-related issues.
My concern
Yes,
is,
Justice.
my concern is that looking at the website, the information all appears to be on the website. It's just you have to click a lot of buttons to get there, and you have to read a lot of very fine print to understand that even though they say on the front page that 5 out of 6 people passed the last 3 exams, and then they talk about cumulative bar passage rate of 81% is 13 out of 16. It's misleading in the sense that you don't realize what the class started at and what it ended at. But then when you click into the website, there's a form, and at the very bottom of the form, it has that data. I'm worried if we don't give very specific instructions to the law school and the dean to say what we want on the front page, we're going to be back here again. And it should be a really easy fix because their website is very clear and easy to read, and websites are not difficult to modify. I wonder if it would be in our best interest and the dean's best interest and the public's best interest to say, this is what we want to see on the part that says 83% bar passage rate. This is the information that we want to see up front. And maybe we want a table that says this is how many people we enroll in our first year, and this is how many people are left at the 4th year, and that gives context to why 5 out of 6 people passed and 13 out of 16 people passed. I think that would be a clear instruction to the dean, something that he could comply with easily, and I think something that would inform people who are looking at this website quickly.
So one potential suggestion would be what we tell most schools, which is to place the disclosure more prominently and more easy to see, because it does have that same information, and all of the schools have the same and are treated in the same way. With this school, the disclosure was misplaced and incorrect. It was eventually replaced, but the current disclosure was down below. It was eventually replaced, but in 9-point font. And finally, we've gotten to the point where we've gotten so far. The school is very insistent in having a splash in the front that is that subset cut that you see.
And I think, I don't know why we could not insist. I'm looking at the website right now. There's the middle part of the website says 83% bar pass rate. You have to click on something that says disclosure. Then you, when you get to that page, you have to click on something else that says annual disclosure. And then it is what I consider to be a complicated form to read through. And only when you get to the very bottom of that form do you understand what happens with enrollment. And I think that's the part that potential students may be misled if they don't click through all of those data points and get to the bottom of the very complicated form.
And the form is actually a statutory
Yes, and I
disclosure.
understand that it is a statutory form. It shows that it is required by the California Business and Professions Code section 61.7 subdivision A. That is very nicely laid out. What I would suggest is that we require them. I'm actually not in favor of giving them a warning letter right now. I'm in favor of, as a first good faith step, and I agree with Vice Chair Yokelson that I think this dean is making good faith efforts to comply. that on the front page of their website where it says 83% bar pass rate, there is something right under that that has a chart and shows this is what the first year class starts at, and this is first, second, third, fourth. And so you can see the decrease in number of students, and it has it maybe over 4 or 5 years. I think a reasonable person looking at this website could digest that data and understand why the 5 out of 6 number is the way it is and why the 13 out of 16 number is the way it is.
Dean Honey, if you're listening, I would listen and address Justice Masiwala's concern, and not doing would not bode well for the school. Thank you. Since Justice Masiwala is suggesting that we take out the warning letter, do we have any opposition, objection to that effect?
So are you asking for a vote on option 1?
Well, we're still thinking about how to amend the resolution in a way that is appropriate for a motion. So unless someone has a very strong preference for the warning letter, I'm okay with what Justice Masiwala is suggesting. We'll take out the warning letter, believing that Dean Han will do this in good faith. And when we come back next time, that we'll see good faith efforts being made.
I do have a question.
Yes, Mr. Reyes.
So what is the remaining time on the other items that need to be corrected? And in your opinion, are these other items serious in nature that it would be hard to correct immediately? Or because what I'm afraid of is if we don't do the warning, because the warning letter would sort of be omnibus, right? It's for this issue that we're talking about, plus the remainder of the issues that are involved that they need to correct. So if we didn't go with the warning letter and we expected this to be corrected in, like, say, whatever, 60 days, what's the remainder of time that they need for the other items? Because those have been ongoing for two inspections, I believe.
They have been. They're primarily in the area of better utilizing the 4-week pre-course, providing academic support beyond pointing them to publications, and thoughtfully considering the performance each year and trying to improve. Those are the key areas. There were significant areas about policies that were loose or conflicting that in some cases harmed students, but they have made significant progress there.
Does the academic support require the school to expend more money from their budget in order to meet those goals?
The team didn't believe so. With the current staffing that they have, and in particular, the individual in charge of academic support has just completed an ABA-approved LLM from a law school in Florida, so he is also receiving additional training himself. I do believe they have the resources to make adjustments at little to no cost.
So for the remaining items, has the staff received any update on where they are on those?
In the response, they did talk about things, but they talked about them in a more general way. So far, for academic support, for example, the coordinator meets with them every other week. They said that they will consider in the future meeting every week, but they haven't decided yet. There was not any update as to what the curriculum change would be.
Okay, thank you.
I'm very energized by Mr. Rare's passion about this topic.
Mm-hmm.
I love that. Yes, Mr. Kramer.
So if we go with option 1, we really don't inspect them for another, I think it's a year and a half. And so we really, unless we, and we haven't set any kind of deadline short of that. So I don't think that works to light any sort of fire. We could, I guess, without calling it a letter of warning, just set a deadline where they have to report back to us. But then at that point, if they haven't satisfied our requirements, then we would have to go and issue a letter of warning. We could make it a pretty short turnaround, but issuing a letter of warning today would truncate the eventual compliance process if that we need to go through that to compel them to make the changes we think are necessary. It's already a long and tortured process that, again, I'm trying to fix, but, you know, other things keep getting in the way of fixing the regs. I guess I understand that a letter of warning might be a little bit of a, you know, a stain on their reputation, but I also think, you know, they've had several, not formal warnings, but several inspections that they've not completely satisfied. So I could go either way, but we definitely need to set a deadline that's sooner than a year and a half.
Ms. Leonard, remind me, with respect to People's College of Law, did we do something like this where we sent them a warning letter beforehand? I mean, I felt like the facts are pretty similar where, you know, People's College of Law also took quite a while to comply with a lot of the recommendations by the committee, but did we ever send them a warning letter?
Yes, you did choose a warning letter in that case. I do think there are some material differences here. And conceptually, choosing the option one, I can see both as viable pathways forward, but choosing option one essentially says the next inspection won't happen till 2027, but you'll have 2 touch points, November this year, next year to check in. And they will have the remainder of this year as well as next year as a school year to say, we made these plans, we implemented these plans, we saw how they behaved in this school year as well as next school year, we evaluated the results, and here's what happened. So it allows them to give you a full report under their own guidance without significant additional cost to them, and it may bring them significant additional revenue if they're able to improve their retention. Choosing the warning letter option, that's an opportunity for you to get a very comprehensive plan early on if you're concerned about them making their own choices going forward, and it reduces their level of flexibility. It's sort of the difference between a settlement, and a verdict. They both have their value and their place. They're just different choices.
I mean, we can establish milestones, right, from now till then, and with the contention, with the requirement that they have to show or demonstrate good faith efforts from now till the next inspection.
I've highlighted in the option 1 motion about the evidence they need to show even in the next annual report.
Yeah, so that language is in there.
Yeah.
So hopefully that addresses the concern about, again, I'm either way works for me. I do want to give the school a chance now that the committee has fully heard all the issues and understood what needs to be done. So unless someone says otherwise, we will go with what Justice Misiwala, my sister over there, has recommended. We'll take out the warning letter. We stick with 120 days to comply, followed by several milestones where we would then need a report from the school confirming the satisfaction of the recommendations.
So the option 1 doesn't have the days. It has.
We could fix it.
Okay, you want to amend it?
We could definitely fix that. But conceptually, that's what I have in mind. But I want to make sure this is what everyone would want as well before we start changing the language.
So I understand your milestones are, the first milestone might be correcting that website in the way that Justice Mesiwala has laid out, so that's clear. Mm-hmm. And then the next milestone might be the remainder of the items that need to be addressed.
Yeah, they have to show substantial efforts being made to comply, and at the next inspection, the goal would be to fully address all the deficiencies.
And that would be in 2027?
I believe so. Is that correct, Ms. Leonard?
Yeah, so you've got 2 interims in there. The first one would be November 15, and that's a reasonable time for them to show that they've updated the website and their communications in general, and also to give you a sense of direction of where they're going on all of the other possibilities. You have an additional a touch point in November of 2026 where they can provide not only their plans, but the status of implementation and what results they've seen so far, hopefully preparing them for a successful inspection in 2027. So that's how option 1 is written at this moment.
You speak?
Yeah, so I agree. I do want to have like touch points with them, but it seems like based on what I'm hearing from Natalie, they're already built in to how option 1 was drafted, right? Like the November 15th. And so I'm concerned that we're complicating it. It might make it more difficult for the staff, but it seems like if we do number 1, they have to report back in November 2015 of this year. So we'll be able to see. And I presume that if they've done nothing, we would hear that back from Natalie, and then we could like take further action if necessary. So anyway, I guess what I'm saying is that I think that the original option number 1 sounds like generally what we want to do without the warning letter, but we already have the built-in check-in, so we don't need to like add that into the resolution. Is that correct, or am I making that up?
That's correct.
Okay. Because if that is correct, then I would like to make the motion for option number 1.
Any seconds?
Well, do we want to directly indicate in option 1 that we want them to correct the website bar results, or no?
On this further resolve, can you see when I am?
Oh, okay.
Yeah, and
Oh, there we go.
part
Okay,
of-
yeah, I see it.
Part of the reason it's written in a general manner is because they do have some latitude as to how their page looks, and they can reskin it at any time. And so we might, you might direct them to change the paragraph in a certain way, but then they may change in the future. So what the team discussed with them is, I mean, just realistically in this situation, their most current bar pass rate was 0. They didn't want to say that. So they created a cut of first-time takers over the 3 exams until they reached a good point. Part of what what the team shared with them was every time you put a pass rate up with a cut, please put the full pass rate up so that the public can see. The first-timers performed in this way, all takers during the same time this way. So it doesn't appear to be concealing something like my most recent pass rate was 0.
Well, I'm comfortable with those details being left to the staff, and this language seems to be okay. It's less
Procedurally, we
less
have-
onerous than a warning
Procedurally,
letter.
we have a motion pending, so I need a second before further discussion. Thank you, Justice Masuela. Now we can continue the discussion. Yes, Dr.
I
Ball.
think the disclosure of nutrition should also include causes based on a study. Otherwise, it all seems like it's the fault of the school.
Justice Masuela, it's a motion, so what are your thoughts about that?
We do. As part of their annual report, students and former students provide self-reported reasons for their departure. And one of the things that the team discussed with the school is that they begin to analyze that data that they're already collecting and reporting to the State Bar, and then take any actions that are appropriate, that are suggested by their findings.
So they're studying it right now. Is that what, it sounds like they're studying it right now.
Yes, and they do have their data from this past year. They're just building up a trend. They'll get another data point in November. They'll get the forms in a couple of weeks, and they'll have that in November. So yes, Dr. Bolton, they will be looking at those reasons. It is based on student self-reported reasons. The students may or may not give the full panoply of reasons why they have that, but it is helpful data, absolutely.
Sorry. I'm trying to think of how to word it, and I missed it. Is the warning letter still included or not included? Okay, all right.
Any additional comments? Hearing none, Deborah, please take roll.
Bolton,
Yes.
Cow not present, Gongora,
Yes.
Kaplan,
Yes.
Kramer,
Yes.
Lawrence not present, Lynn not present, Masiwala,
Yes.
Montgomery,
Yes.
Peak,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Reyna,
Yes.
Reyes,
Yes.
Yokelson,
Yes.
Chan.
Yes.
With 13 yeses and 0 nos, the motion passes.
Thank you. It's almost 1:30. I think this is a good time for lunch break. Let's break for 45 minutes and we will come back at 2:15. Thank you.
Oh my God, I was so mad.
So I am going to turn it back to you, Mr. Chair, to make what maybe was the oral report under the chair's report before I say anything else.
Well, thank you. As you know by now, we have newly elected or appointed chair and vice chair. So I want to take a moment to welcome the incoming leadership team. Congratulations, Mr. Yokoson and Ms. Silva Guzman, chair and vice chair, respectively. We're really fortunate to have you take over the next term and also have Ashley being the vice chair. Your experience, your judgment and energy will be so valuable as this committee continues its work. And I want you to know that you will, well, first I will miss all of you and I will give my speech later, but on behalf of the committee, we'll welcome both of you to be the next term's leaders.
It's going to be hard shoes to follow.
I respectfully disagree, but thank you.
I have more to say on that later.
Thank you again. Welcome.
And that's going to be it for the oral report. Under 5.1, I think we can move on to item 5.2, which is just a presentation of the work plan. I will go on ahead and share my screen. Okay, so in your materials, you saw that I posted the work plan, and all this is taking all of the discussion that we had at the last meeting, where we identified things that we're removing from the work plan, things that we're adding to the work plan, and I've just incorporated everything in, taken out the things that we said that we are removing. And I just wanted to present the work plan to you in its final form. I will note two things.
Hey, sorry, Donna. We're having difficulty hearing you. Do you mind speaking into mic?
Sorry, the microphone is not on.
Thank you.
So I just want to note a couple of things on this work plan. First, I'm going to scroll to the very end of what was included in the materials that were posted. And I just want to show you that this, I wanted to make sure to capture items that we took off of the work plan, but that require us to do something. So we didn't lose them. We are making sure that staff is tracking these additional items, and will be putting these together as appropriate, whether it's putting it on the next year's work plan, or doing trainings of the recordings of the presentations, et cetera. So I just wanted to show you that we have captured those items that required future action. The other thing that I want to scroll back up to, capturing our discussion earlier today, I have added here an additional item on the work plan, pursuant to Mr. Kramer's suggestion that we put this on, and that is that the committee explore whether to develop performance targets for key indicators of, and this is in the educational standards section, key indicators, let me just add, of law school performance, and to present those recommendations to CS bars for input. And so we've gone on ahead and I've gone on ahead and added that item
to the work plan. You can see in the item above, I just caught it, an inadvertent omission, and I just added the reference to goal 2, but otherwise, the work plan is what you saw presented in your materials for today, and I'm happy to discuss any of it, but this was really just an opportunity to effectively capture everything we did at the last meeting in terms of what was being removed and what was being added.
So process questions. This means that the subcommittee would prepare this, take it directly to CS bars, and then before it came back to this full committee?
That is what I envision, yes.
Okay, well, the subcommittee never meets separately from this. So you're talking about just Vincent and I as the officers?
Yes, so that's what I think what we discussed, the two of you working with Natalie and others on staff to come up with some recommendations to explore whether you wanted to come up with recommendations, and if so, to come up with recommendations for performance targets, and then have a discussion with CS bars about it, and then bring it back to the full committee.
Okay, December is probably a little quick, but.
It probably is, but being that this is the 2025 work plan, I felt the need to put something on it that was probably within that, but I had that same thought.
Yeah, with that understanding, that's fine.
There are no other questions. That's the end of this item.
Great.
I will stop my sharing.
Thank you, Donna. We're going to go back to agenda item 1.4, which is the recognition of outgoing members. I'll hand it to Alan and Audrey.
Well, I will hand it to Alan.
I'm sorry. First of all, I have to stand. I hope I can be heard. Is the mic working? I need to stand out of respect for, we have the video here, out of respect for our outgoing chair, Alex Chan. Alex, I can't, if I could make the resolution now, I am sure it would be seconded and unanimously approved that you stay on and that you stay on as chair. You have had such an impact this year and during your tour on the Committee of Bar Examiners. So for those of you who don't know, Alex got a pretty distinguished background outside of this illustrious organization. Alex actually has a BS and an MS in electrical engineering. Okay, something my father had, something that I could never aspire to because I can't do math. He attended New York University, J.D. Franklin Pierce College, Law Center. And separate from the Committee of Bar Examiners, Alex, you've been active in all kinds of community organizations, the Minority Trial Lawyers Committee for the ABA, fellow at the Law Practice Division of the ABA, and so on and so forth. I can't even begin to mention all of these. And I also remember from one of our dinners that you're a fencer, right? Alex has grown up with the art and the science of fencing, the sport of fencing, which I guess metaphorically is appropriate given your sharp wit and the forward thinking and the methods which you, the tactics, the strategies from which you have led our organization. As CBE member, you joined in 2017. You were a commissioner, but you didn't just sit on subcommittees here. You were also a commissioner on the Blue Ribbon Commission for the Future of the Bar Exam. You were a member of the Differential Item Functioning Analysis Working Group. I have no idea what that is, Alex. I'm sorry. You'll have to tell me one day. But you did that. And then, of course, you were a member of the Informal Working Group for the administration of the California Bar Exam. You have served on this committee during two of the most difficult times in this committee's period. the COVID experience in 2020, getting through all of that, and you helped guide this committee at that time. And then this year, which at the beginning of last year, seemed like, it's going to be a challenging year, but nothing special. As we all know, it turned out otherwise. And it is your wise leadership and your foresight that got us through this, frankly. You've done a fantastic job. You've been intellectually honest, and above all, you're dedicated to the two pillars, what I consider the two pillars of the California Committee of Bar Examiners. Public protection, but at the same time guaranteeing all persons in California the opportunity to seek a license in the practice of law. Those are often two competing interests, and you have been dedicated, somebody used the word earlier today, a warrior for justice for applicants, but also public protection. I just can't say enough. As vice chair, you've been completely transparent and involved with me, and I really appreciate that. I love getting the phone calls and the messages saying, hey, Alan, we got to talk about this. We just had this meeting. You've been a true friend, and I'm really going to miss you from this committee. I think that the true leadership, or the true test of any leader, is leaving an organization in a better position than when you got here. And in just this year, you have accomplished that. So Alex, we will tremendously miss you. We wish you the best of luck in your future endeavors. And
You actually get 2 certificates.
and we are very honored, I don't know, this small token that you can take on the plane with you back home.
Yeah,
Oh my
or we
God.
can mail it, either way, because you were chair, vice chair, so many hats.
Oh, God, Alex. We miss you. We miss you
Don't
already.
go.
Yeah, don't go. I make the motion. Can I have a second? Thank you, Alex.
Well, thank you. Sorry, I'm a little bit emotional at the same time. Let me just take a moment to reflect, because I feel like we all need to reflect exactly what we had done in the past year or so. When I stepped into this position last year, I did it with an understanding of all the challenges ahead. And the February 2025 crisis was by far one of the most serious and high-profile issues this committee has faced in recent memory. But I also saw that as an opportunity to lead with transparency, to take accountability, and also just to show the public and the profession that we could rise to meet that moment. And rise we did as a group. And I'm just really proud how this committee responded with urgency, with clarity, and compassion. We listened to applicants. We confronted with the errors. We acted decisively to deliver all the appropriate relief to those affected, while at the same time safeguarding the public interests. And that we're able to hold our heads high through it all is really a testament, not to my leadership, but to your leadership. And for some, this year has been about surviving a crisis. But for me, I feel like this year has been about building trusts with the public, with the applicants, and also the institutions that rely on us to uphold the integrity of this licensure. And we didn't just manage a setback. In many ways, we leaned into it, we confronted it openly, and we turned it into an opportunity to reaffirm who we are and what we stand for. And through swift action, open communication, and also just staying grounded in our values, I truly believe we built a lot of trust in the process and also strengthened our reputation to lead during the challenging time. And we don't have to look any further than the California Supreme Court, who has not just once, but repeatedly affirmed its confidence in this committee as the steward of attorney profession
And that trust has come through not just in words, but importantly, it has come through in action. And over the past year, the court has really consistently relied on all of you, this committee's leadership, to navigate all the complex decisions, including the experimental exam in November, the February bar exam, but also the ongoing bar exam reforms. And most recently, the amendments to Title IX, which we discussed extensively last week with the Board of Trustees, would expand our authority over critical areas such as budgets and fee setting and also operational oversight, recognition that this committee is not only capable of doing thoughtful policy work, but also is trusted to manage the infrastructure that supports it. And this is not just a symbolic gesture, it is really a substantive endorsement of the depth of our work and the soundness of a judgment, as well as the strength of your leadership. And so to each of you, I really want to thank you for showing up, for the hard work, and for never losing sight of what we do or why we do this. I have seen you wrestle through tough questions. We even challenge each other's with respect, and we make decisions based on your own conviction. And you have reminded me that good governance isn't about perfection, it's about responsibility. And with that, I want to thank a couple of people, the old guard, or what I call the brain trusts. That would be Mr. Kramer and Dr. Bolton, Mr. Lawrence, who's not here, and Mr. Kaplan. You're appearing remotely. Your experience, your discipline, and your sheer stamina really continue to set the bar. You guys have been on this committee far longer than anyone else. And you have oftentimes showed me about what it means to have good work ethics and just the countless years you have dedicated to this committee. I'm so thankful for all of you, just being a sounding board. And then to Dr. Cow, who is unfortunately cannot be here, and also Mr. Ngora, Ms. Lin, who's also cannot be here, Ms. Peak, and Mr. Reyes. You have been, in my view, this committee's key driver for past several years. You've been really our compass and our bricks and sometimes hazard lights, because you really help us understand what it means to be grounded in our values and reasoning, and just really help us make an informed decision on everything. And I'm really grateful for that. And then we have the new group. We have Justice Maciwala, we have Judge Reyna, and Ms. Silva Guzman. You have proven experience serving on this committee may be overrated. You really jumped into this committee, you roll up your sleeves, and you brought this committee like a breath of fresh air. And you give us your sharp insight, and you give us judgment from day one. You have made it very clear you don't really need tenure to leave a mark, and I thank you for that. And finally, to Ms. Smith and Mr. Montgomery, our newest member to this committee. I know you guys sort of walked right into the turbulence. As the turbulence was starting to clear, or so we told you, but you barely had time to finish reading our CBU manual, and yet you have given us a really new set of eyes to all the core issues. You have given us thoughtful insights and give us your steady presence. And you may be new to the committee, but in my view, you are really part of the story already, and I'm confident you will help write our next chapter. And last but not least, I really want to thank the State Bar staff, Erica, who's not here, Donna, Audrey. See, she's still working she's, and Jean, Devin, Tara, and Mia, and all the folks in the back. Bethany. Thank you. Oftentimes we don't talk about them enough because they're sort of like the behind-the-scene people. You have done all the heavy lifting from logistical to administrative, doing all the invisible weight of this committee's work with utmost professionalism, and from tackling down all the obscure rules that I sometimes don't even know what they are, to prepping all the bar materials and then coordinating all the public comments, which we have had many, and also just answering all the policy questions that we have had around the clock. You have done it all. and then more, and then much more. You really have made it possible for this committee to focus on the substance, and for me personally, to lead with confidence, knowing that the operational foundation is really strong as I am about to depart. But even during the most challenging moments of this past year, our staff has never flinched. You kept the wheels turning, all the applicant files organized. You have, keep your tone professional, even when we disagree with you. And you do it with a smile. Please know that your work matters and it doesn't go unnoticed ever. And so I want to be very grateful for your dedication and your patience and just your unshakable commitment to what we do here at CBE. And so, it's been the honor of a lifetime serving as a chair. And while I am stepping away to focus on my family, I remain optimistic, and I'm going to be very energized knowing that Alan will take over. We have the momentum, we have the purpose, and we have each other. So thank you to all my brothers and sisters for your trust, your collaboration, and your dedication to this committee and to the public we serve. Thank you. We do have one more. I know Esther is not here today, but I do want to say something quick in recognition of her contribution. She is concluding her term on this committee. Unfortunately, she's not here today, but she was a former chair of this committee. And as a former chair and long-serving member, she actually has given us extraordinary amount of time, energy, and wisdom to this body. Her steady leadership, her thoughtful guidance, and her deep commitment to the profession have left, I believe, a lasting mark on this committee's work. And so we're grateful for your service, Esther, if you're listening, and we wish you nothing but the very best in everything that you do. Thank you.
We'll send it to her.
And with that, this concludes our open session. We will now go into closed session for members on video. Please dial into our closed session now. Thank you. And for the public, we'll be back as soon as we're done with the closed session. Thank you.
Yeah. I was like, Robbie, for real? Like, put them somewhere else. Yeah.
Session. There is no reportable action from our closed session, and all meeting businesses have now been concluded. Thank you for your time, and meeting is now officially adjourned. Have a good weekend, everyone.